For judgment,
That is the
item number 1.
In the facts and circumstances of the case and in the backdrop of the above discussion, the compensation amount is modified in respondents' claimants hereby awarded a lump sum amount of 5 lakhs, along with interest of 7.5% from the date of filing till payment. The total compensation inclusive of it within 3 months. The instant appeal stands allowed to the extent indicated above and is disposed of. I have discussed actually 163 and all that I have discussed, which will be applicable. I have discussed everything.
Yes.
So you have a look later.
Bless you, Lordship. Lordship, if I may be allowed to withdraw the statutory amount of 25,000.
Okay, that is true.
Yes.
Statutory amount, just remember, statutory amount shall be allowed to be. Just insert that line in this.
Bless you, Lordship.
Please, Your Lordship.
Just, I will stand disposed of. Yes.
Judgment is always like an exam for us.
No, no,
Like we are student.
no.
My lord, if
Yes,
it is
sir.
not inconvenient, your lordship, my lord, to yesterday's matter,
Yeah,
can it be taken up, my lord, once the motion is over, my lord,
after the motions.
after the motion?
Okay, any case it is.
Because there are few items in the
The,
supplementary list.
these, okay, then definitely we can consider that.
I'll not
4,
take,
5, 6 and 7 are connected.
yes, yes,
one
I'm-
matter.
after the, yes. After the motion matter is over. my lord.
Okay. Make the mentions.
Please, Your Lordship. Lordship, item 21. Lordship, as per item
21,
21.
Okay.
Hearing item.
hearing matter.
As per order dated 11/6, it was to be 11/6/2026. It was to be listed after revocation.
Mhm.
I think it has been wrongly listed.
Oh, you want to do it after vacation?
Lordship,
Okay.
the
You also. You offer the response.
respondent 1, 2, and 3.
Counsel for the respondent number 1, 2, 3 submits that the matter was supposed to be listed after the vacation, but has been wrongly listed to the praise for listing after a few weeks. The learned counsel for the appellate has no objection. List the matter after 4 weeks. You want a date? I think let's fix a date,
Yes,
then it will be better for your preparation. You know where exactly it is coming. So you can suggest me a date as per your convenience. After reopening, how about 16?
My lord.
16,
17, my lord.
Huh?
17,
17,
my lord.
no, 17 July.
Oblige, my lord. May it please your lordship. Lordship, I beg to mention item number 8, your lordship.
8,
Yes, your lordship. Your lordship, here I filed an IA, your lordship, for impletement of a party, your lordship. For the IA is yet to be listed. If the matter can be listed with the IA on Monday, upcoming Monday.
counsel for the petitioner submits that to include a new incumbent, and IA has been filed, but the same has not yet been listed. List the matter next week or on Monday.
Monday, your lordship, 22nd, your lordship.
List the matter on Monday. That is so date.
Much.
Yes, ma'am.
Thank you, Lordship. Lordship, I beg to mention item number 17. As per office note dated 12/6 of 2026, await service report upon all the respondent.
Is awaited.
Yes, Your Lordship.
We'll wait for some.
Yes. So can you list this matter after
After.
vacation?
Your good name, please, ma'am.
Tia Kriller.
Okay. Learned counsel for the appellant insurance company submits that service report upon all the 4 respondents is awaited. List the matter after 4 weeks on a date to be fixed by registry.
Obliged.
Yes.
Yes, Your Lordship. Your Lordship, I beg to mention item number 3. Yes, Your Lordship.
Yes. Then
Your Lordship, I have just received the counter affidavit filed by the respondent,
file a reply.
only today. So I pray the matter be listed after the vacation.
The learned learned counsel for the petitioner submits that The petitioner side would like to file a reply to the counter affidavit file. Counter affidavit is being filed by which
No, your lordship, I am representing 2 and 5.
2 and 5.
2 and 5, your lordship, that is the respondent department.
Main respondents.
They are the main
They
respondent.
filed a
I have filed my counter, your lordship.
2 and 5.
Lordship, what happened in this matter is that the regularization of the petitioner service is being placed before the MRC. Now, from the department side, whatever we could do, we have done it, and it has been placed before the MRC for its approval. Thereafter, it will be sent to the cabinet, your lordship. So, if some sufficient time can be granted to us, your lordship.
So your instruction is that the respondents have done their part.
Yes, they have done as per the office memorandum. your lordship.
You can file your reply and then we can wait for some time. Take a call after the vacation, updated vacation. After 6 weeks,
Yes, my
that
lord.
will be, is it okay?
Objection, Your Worship.
What did I say? The file, to the counter affidavit filed by respondent number 2 and 5. Huh?
Yes, Your Worship.
2 and 5.
2 and 5 first. So, it is also Mr. Angam representing the said 2 respondents also submits that the matter has been already processed at the level of the said 2 respondents and has been sent to the what is the full form of MRC?
Manpower Rationalization Committee.
From the to the MRC, write the full form, Manpower Rationalization Committee, and thereafter matter would be sent to the cabinet for final approval. In this context, it is submitted by the learned counsel for respondent number 2 and 5 that the said 2 respondents have done their part in towards compliance with the order of this court, which had given rise to this process. Nevertheless, the petitioner may file the affidavit in reply if so advised. List after 6 weeks.
Yes, Your Worship.
Deeply obliged.
Your Lordship,
Please.
I also beg to mention item number 14. Your Lordship, as directed by this honorable court, we have taken steps upon respondent number 4 through speed post and justice service. However,
Number 4.
yes, Your Lordship. However, justice service is still under process.
The compliance is affidavit you are filing, you're not yet filing.
Yes, Your Lord. Amended petition has been filed, but notice upon respondent number 4.
The learned counsel for the petitioner submits that some more time is needed to complete the justice service upon respondent number
4, Your Lord.
respondent number. Prayer is allowed. List after 4 weeks.
1 week.
1 week.
Yes, Your Lordship.
List after a week.
Much obliged, Your Lordship.
Lordship, I also like to beg item number 11, Your Lordship. Item 11, Your Lordship, the petitioner has filed one reply this morning. If this matter can be listed on Thursday again, Your Lordship.
Next Thursday.
No,
This Thursday.
this Thursday.
No problem. Learned counsel is heard the petitioner and Mr. Angami learned for you are presenting respondent number
1, madam.
1, respondent number 1. Full stop. It is submitted that affidavit in replies filed by the petitioner side has been received today and praised for listing matter on Thursday. List the matter on Thursday, which will be
18th, madam.
18/6.
I'm deeply obliged.
Yes,
His Lordship, Lordship, I beg to mention item number 10, 9, 10, and 18.
10 and 18.
Yes. Lordship, in this matter, we have sent a letter to the Deputy Commissioner to re-verify again because his earlier report was not in consonance with the court directions. So we had already sent a letter to the Deputy Commissioner.
Re-verification of it's a land matter.
It's a land matter. So Lordship, I pray that sometime may be given to us this
My lord,
matter after 3.
If I may, just
Yes.
make one submission,
Yes,
Lordship.
Mr. Long.
Lordship, the order was passed in the month of May last year. 6 months was given.
Yes.
They have made their verification. Now, they've been seeking time to place instructions, Lordship. So just on verbal submission, they cannot keep on,
That's true.
yes.
But,
So at least let them place something on record to show that they are actually seriously taking the matter.
Unless the deputy commissioner verified, we cannot do our partnership. And I'm not for the deputy commissioner.
Simple direct. Litigation. Service. Mr. Toshio Longkumar, counsel for the petition, and the learned additional advocates representing respond number 2 and 3.
2 and 3.
2 and 3. This lays, so the additional agent submits that the towards compliance with the order of this court. An earlier report received from the concerned deputy commissioner, Mokokchung. Mokokchung.
Lordship.
Mokokchung. Suffered from some ambiguities, and therefore it has been freshly requested to the said authority, that is the Deputy Commissioner Mokokchung, to make a verification and submit a report. It is submitted in this context that for the said purpose, some time may be given. On the other hand, Mr. Longkumar submits that the order was, or the order in question was passed by this court in May 2025 itself. And the compliance period of 6 months is long elapsed, and he seeks an early adjudication of the matter. A copy of the said communication sent to the Deputy Commissioner is placed by the learned additional agent, kept to the record. List the matter after her,
4 weeks.
after 4 weeks.
Should be, an observation may be made that they, by that time, they will place on
Lordship,
record
this is a
verification.
claim matter. I'm not for respondent number 3, and the court has
Because-
specifically directed respondent number 3, and respondent number 3 is yet to enter evidence, and I'm not for respondent number 3.
Contempt is actually not an execution mode, but
Yes.
by default it is.
Yes, Lordship.
By indirectly it is.
Understand.
So it is submitted by the learned additional AG that from the point of view of the compliance of the order, the main respondent is respond number 3.
Respondent number
Just check that. Respond number 4.
it's 4.
All the respondents, especially respond number 4, shall make their position clear, expeditious,
This is not a, no, we cannot.
as to the step taken towards compliance with the order,
Yeah, we cannot repeat the decision.
especially when
Yes.
the period prescribed for the same is long over.
Verification.
I don't have the file, so please leave it in the file.
Direction was issued 1, 2, and 3.
So the same order, being the same order,
The same.
Yes,
order.
sir. August 1st.
right? 9, 10, and
18.
18. Same order.
Right, Lordship. Yes. If there is no directs them, no, directs them, we should be.
But like,
Wait, please, Your Lordship.
Yeah,
Lordship, with regard to item number 4 to 7, Your Lordship. In item number 4, I'm for the respondent, private respondent, Your Lordship. But in
the respondent in item 4, 4 and
Yes, Your
5.
Lordship.
Item
In
number
other matters, we are for the petitioner, Your Lordship.
Yes,
But we need to file an affidavit, rejoinder affidavit. Lordship, kindly grant us 2 weeks time, Your Lordship.
Madam, you are for?
Lordship, I'm for respondent, I'm for the petitioner in item number 4, and in item number 5 and 6, I'm for respondent number 1. Yes, so they're yet to file their affidavit in item number 4, my lord. Therefore, the respondent in item number 4, so they're yet to file their affidavit.
And bail application?
There's an anticipatory.
They're all
bail, my lord.
connected.
Yes, my lord, they're all.
Your Lordship.
So all will get adjourned?
Yes, my lord.
Third,
Respected.
in four, you just take the petition. Four. Third learned counsel,
Miss-
you are in petitioner.
I'm for the petitioner, item number 4, my
For
lord.
the petitioner and Mr. S. Gautam appearing online for the respond number two.
Respond number 2, my lord.
Respondent number two. It is submitted that in item number four, you are going to file an affidavit, right?
Yes, your lord. We are going to file an affidavit.
You submitted that some time is needed to file an affidavit on behalf of the said respondent. Full stop. Full stop. This is the matter, but 2 weeks will merge into it will fall in the vacation.
Yes, my lord.
Lordship, after petition, your lordship, in the month, third week of July.
Immediately, it will be immediately after reopening. Since
Yes,
we
my
are-
lord.
Yeah, third week of July. Yes.
third week.
List in the third week of July. Full stop. Any interim order in four?
No, your lordship.
No.
No, my lord.
This is done. Now, five. Five is you are for the respond number?
Yes, my lord. Respond number 2.
Who's you are appearing as for the petitioner in five?
Yes, your lordship. I'm for 5.
Bottom appearing online for the petitioner, item four, right? And Miss Learned Counsel appearing for respondent number two.
2, my lord.
Respondent number two. Full stop. What is the prayer here?
My lord, in regard to the respond number 5 and 6, pleadings are complete, my lord. We have already filed our affidavit.
You want
Yes,
to
ma'am.
file a reply?
Lordship, in item number 4,
Five.
that will petition, your
Five,
lordship. If
four I have dictated, five.
Yes, your lordship. In 5, I don't want to file anything, your lordship. The affidavit that I'll be filing in item number 4, that will be sufficient, your lordship.
Okay. It appears that the affidavit has been filed, it is submitted that affidavit has been filed on behalf of respondent number 4 and 5. And pleadings are,
Respond number 2, my lord.
respond number 2,
Yes, my lord.
respond number 2 and pleadings are complete.
Yes, my lord.
The pleadings appear to be complete. And so it can be posted for hearing.
Lordship.
Uh,
Once they file their affidavit, my lord.
List in the third week of July, just
Yes, my
come
lord.
together.
Yes, my lord. And if
And,
needed,
and six, item six, you are for the petitioner.
Yes, your lordship. 6, 7, I am for the petition.
Any interim order in five? No.
No, your lordship.
In six, Mr. S. Gautam for the petitioner and Madam for the respond number.
respond number 2, my lord.
Respond number two. What is the submission here?
Lordship, here also we have already filed our affidavit.
Same. Just in third week of July, along with the connected matters.
Yes, ma'am.
And AB, you are the petitioner. S. Gautam, item 7 for the petitioner and for what is the submission here? Any interim order?
No, your lordship. There is no interim.
There is no interim order. Case diary?
Case diary, I was called for, your lordship.
Okay,
my lord.
but scan copy?
Scan
Full stop.
Lord-
The scan copy of the case diary has been received and shall be regained. As the matter is being posted after in the third week of July, along with the connected matters, the learned PP is requested to procure scan copy of the up-to-date case.
My lord, and item number 4, if we may be given the liberty to file a reply if needed, my lord, to the affidavit filed by the
Okay.
private
In
respondent.
four, just add a line. The petitioner side is at liberty to file reply to the counter affidavit if so advised.
Oblige, ma'am.
Lordship, a date may be given, your lordship.
Date, you want a date?
Your lordship.
But not bad. Third week of July. You choose a date. 16, take it out. 14, 16. 14
I
and
don't-
16. They're best date.
Immediately on reopening, it will be difficult for me, your lordship. Can it be on 21st?
Okay, 21st. Then third week of July, it won't be. No, remove that.
Okay.
Fourth week of July. Fourth week of July. Instead of third, right? Fourth week of July. Let the sentence remain. Otherwise, you have to cut a lot. List on 21/7/2026. All the matters.
Oblige, ma'am.
Pleasure.
Yeah, motion.
For motion from the supplementary cost list, item number 22.
First time.
Yes, yes.
Execution office. the Oriental Insurance Company, the Oriental Insurance Company Limited, as the appellant has invoked the provisions of section 173 of the MV Act 1988 to file his appeal against the judgment and award dated 19/3/2026, passed by the learned member MACT Dimapur in MAC case number 58 of 2024. The respondent number 1 and 2 were the claimants, and respondent number 3 and 4 are the owner and driver respectively of the concerned vehicle. The appellant shall take steps of notice upon respondents by speed post.
Yes, Your Lordship.
Call for the original TCR of so and so case from the learned tribal. List the matter after 5 weeks.
Lordship.
After 5 weeks.
Yes. Much obliged, Your Lordship.
Anything in the IA is for stay.
Yes, Your Lordship.
Let me take up that, please.
For motion, item number 23.
Mr. Devnath is not there. He may join later. I will take up after some time. He may join on.
For admission. For heard matter, criminal petition 43 of 2025, item number.
Several of them got.
No, if your
adjourned.
lordship want to take admission item number 3, your lordship can take. I can wait, no problem.
No, 3 is adjourned.
Raja.
2 is there. 2 is there. Would you like?
2 is, yes, if you like to take up the matter, I can wait, no
Admission
problem.
2.
For admission, item number 2.
I can wait, no problem.
Senior counsel, accommodated. Take much time. Then you'll be free.
Lordship.
Immediately.
Lordship, I'd like to mention on behalf of Mao Intel Lordship.
PNR department.
Lordship,
Yes, yes.
if Lordship may, we are here to receive instruction if Lordship.
Frustrating delay in all cases.
Yes, my lord, this contempt is against the order dated 10/2/2022. Plus
Already.
in 250. Now that it's already 4 years now since the
That's
order.
too much. That's really too much. Of course, we should also fix realistic timeframes, but if the time frame is not unrealistic or unreasonable, then it should be complied. Actually, whenever a time frame is fixed, but the compliance is not possible or some difficulties is being faced, ideally an IA should be filed in the disposed of repetition. To seek extension after 2 weeks.
Lordship,
Then even the contempt aspect will be little watered down in that case.
Lordship, we may allow to take a necessary instruction after.
my lordship, just 1 minute, if I may be allowed.
Go ahead.
My lord, this court order was directing the respondents to regularize my service as per the prevailing OM of 2015 for regulations of a service. Now, as per the OM, as per the office memorandum, which is at page number 15 of the contempt petition, my lord. I'll just take you to page number 15, the operative portion. Page 15,
Just a minute.
here.
Just a minute. You're representing which respondents?
Lordship, I'm for respondent number 3 and respondent number 1 and 2 is represented by Mao Intel Lordship.
Okay, and you are 3 and 4. You are 3 and 4.
Lordship, he has some personal difficulty today, Lordship.
You are representing 3 and 4. Oh. I just write. Heard so.
My lord, just page.
Just, I'll come to.
Yes.
Lordship,
Mr.
1, 3 and 4 is represented by Mao Intel Lordship. I'm for respondent
Yes,
number
1 and 2 represented by the.
I'm for respondent number 2 and 1, 3 and 4 is represented by
1
Mao
and 4 represented by more
Intel Lordship.
and council represents respondent number 2. It is submitted that Mr. M. Chen has some personal difficulties to lodge. The learned counsel for the petitioner submits that he's seeking he's aggrieved by non-compliance with order dated 10/11/2022 itself, passed by this court in WPC 250 of 22. Yes, which page?
Page 15, my lord. Page 15. This is OM of 17 March 2015. Page 15, the operative portion. If you check for it, page 15.
Click on the main petition. Page 15
Yes, 15.
of your petition, right?
Yes, yes, madam.
Go. Yeah. Yes.
Clause H2, Roman 2. Clause H, Roman 2. Here it, my lord.
Clause H2.
Yes.
Yes. In respect of.
In respect of those who are church and casual employees in scale pay and who have completed or will complete 30 years of continuous service after 1/1/2015, their cases for regularization will be taken up subsequently in 2 pages, that is, as on 1st July and 1st January every year. So like my lord, next month is January. So if the matter can be expedited. If again,
Yeah, next one is July. Approaching, coming July.
coming July,
Coming
and then if this time it is missed, then again I have to wait for January again. So
No, the learned counsel for the petitioner, let me write down this, has drawn the attention of this court to to the office memorandum dated 17/3/2015. More specifically, clause
H2, Roman
1H2, which reads as follows. You lift this. In this context, it is submitted that the next batch of such consideration for regularization would be on the coming 1st July, coming 1/7/2026. And therefore, the matter needs to be expedited, failing which the petitioner seeking compliance with the order passed by this court shall have to wait for the next timeline of 1st January 2027. Yes. The respondents shall keep this aspect in mind while doing the needful towards compliance with the order passed by this court. List after 4 weeks. So, yeah, please come. Yes, just leave it. Yes, part. No, part. Yes, sir, please come.
Written note. We prepared a written note
Oh,
yesterday, and
be very helpful.
I give other side also.
Oh,
I've given the other side also. PP also, I'll give. If you ask any PP.
very well.
One PP also. And not all the submissions.
Credit to your team.
He prepared,
I'll be-
but this is the opportunity that your lordship has given.
No, so
Otherwise, I mean,
I'll also benefit. I can keep it in my notes.
yes. All the judgments, everything has been, whatever we argued, my lord.
Yes.
All the submissions have been, my lord, we made. And if you see at page 2, my lord, of the written argument, table contain introduction.
Yeah, so nicely made.
Table contain, we have given the page number with all the judgments, what we cited. And first, if your lordship looks into it, the page number 3, the case of the respondent number 2, what my learned friend as yesterday he argued. Yeah. This is his case. 1, 2, 3, his case, what he argued.
Right.
And that up to. So all this is the argument which is advanced up to page 5 to see para up to para 10. Then B, registration allegation in the FIR. This is what he said. Then if your lordship kindly see para 12. If you see at para 12 at page 6.
Yes.
The entire basis of the FIR is a financial transaction between respondent number 2 and Mr. Arun Batoria in December 2010. It is alleged that Mr. Arun Batoria sought a long-term loan or rupees 5 crores for 4 years, promising a 30% return on the loan amount. Accordingly, Mr. Pradeep Agarwal introduced Mr. Arun Batoria to respondent number 2 on 10/12/2010 in Thekakua village, Dimapur, Nagaland, where respondent number 2 allegedly handed over rupees 1 crore in cash, agreed to pay further rupees 4 crores on 17/12/2010. Now I'll pause for a moment and I'll trouble my lord. Yesterday, my learned friend PP has said that he had read 3 statements before this court. One is the statement of the complainant, if your lordship has made a note of it, is a complainant statement he has read, which your lordship is also fine at page 37 of my criminal petition. 36, my lord, it starts where my learned friend has read yesterday. And already I also read. So I don't want to trouble again. Please see at page 36 and
36 of the
36 of the petition where my learned friend read yesterday statement of the complainant. If the informant, and if you see at page 36,
Page 36.
36 and see the bottom, my lord, 36 of the bottom, which my learned PP has referred yesterday. The complainant was thoroughly examined and stated, he's a businessman. No, I don't want your lordship has seen so and so with Pradeep Agarwal and mutual friend, and they engage in so and so. 37 also, my lord, first paragraph. This is what he said: real estate, good deal profit, 10/12 at so and so. Introduce Pradeep Agarwal to Arun Batoria. So now, my lord, reading of the statement of my learned friend, the assurance part, your lordship kindly see, in real estate which could yield good profit on 10/12/2010 at so and so, he was introduced by Pradeep Agarwal to Arun Batoria, who represented himself as one of the director of Mrs. Afcon, having his office at 4th floor Park so and so. Arun Batoria proposed that if he invested in the company for a period of 3 to 4 years, company would return the invested amount with 30% profit, though initially spectacle. So he was initially, there was spectacle on his mind. On the assurance of Pradeep Agarwal with Mr. Arun Batoria about the company's financial soundness, he agreed to invest. Accordingly, on 10/12, he handed over 1 crore in cash in so and so. Thereafter, on 17/12, at the office of Epcon, so and so he handed over 4 crores in cash to Arun Batoria in the presence of Pradeep Agarwal and other directors of the company. So assurance was given only by these 2 persons, my lord. One is Arun Batoria and one is Pradeep Agarwal. So I was going back and I was looking at, my lord, the money received. If it was on Calcutta, what my learned friend informant was arguing, that deception has taken place at Kolkata. If I'm not wrong, that was he was projecting before the court that we stated 2 dates. One is 10/12/2010. And we stated the initial deception has started at Dimapur. That is the initial deception. Because assurance was given by Pradeep Agarwal that if you invest this money, then you will get something. So initial deception is at Dimapur, not the initial deception at Kolkata. That's my reply, what my learned friend has argued. He said that no, at Kolkata, there was parting of money of 4 crores. Now I am asking myself, if there was a parting of money of 4 crores, why at that relevant time, why this 2 person, why this Milan Shah was not brought in the picture? Because if that money received, I don't want to trouble again. See the money received, my lord, at page 54. If it is 17/12, see the money received at page 54. in the revision petition,
Yes.
criminal petition.
Place 54. Yes.
If deception was here, my lord, then why at 17/12/2010? Please see, receiver rupees 1 crore in cash on 10/12 at Dimapur. So this is the initial deception what has taken place. Not cannot be at Kolkata.
Right.
And kindly see what the word, an amount of rupees 4 crores in cash or from in presence of Pradeep Agarwal. So why, my lord, why other directors, why Milan Shah was not were spelled out? If these directors were present at Kolkata, and what is the statement, my lord? If you see the FIR, please see the FIR at page 29. I can connect this, my lord. Please see this. Please see at page 30, my lord, the FIR. Please see the FIR at page 30. Relying upon, kindly see third paragraph. Relying upon such assurances, I see so and so, the undersigned handed over a sum of rupees 1 crore only in cash. Lordship got it? On the same day, I agreed to give a further sum of rupees 4 crores on 17/12/2010. Now, if that was 17/12/2010, I agreed to pay father of some rupees 4 crores on 17/12/2010. Why not? I am asking myself at 54, why the name of the other directors, including Milan Shah, was were not mentioned. See, my lord, the next paragraph. Subsequently, in furtherance of my earlier assurance on 10/12/2010. So, my lord, 10/12/2010, if at all deception has taken at Dimapur, where is the question of deception taking place at my lord Kolkata? A sum of rupees 4 crores in case was given only on 17/12/2010 by me to see Arun Batoria in his office in presence of Sri Pradeep Agarwal. See, my lord. And 3 other directors have got. Now, namely accused so and so, so and so. So now, my lord, I am asking, if this be the case, why their name has not been mentioned in the money receipt? If you see the money receipt, their name has not been mentioned. This is what I want to connect, my lord.
I have brought it with me.
Yes, my lord. Because I went back and I have seen your lordship was pertaining too important. Where, my lord, my whole case I have to satisfy prima facie, my lord.
Yeah.
Reading in between the lines, whatever was there before this court, my lord, whether any case has been made out to go for a trial.
Milan Shah.
This is what, my lord,
Yes.
your lordship will look into it, not beyond that. Your lordship is not on sitting as a trial judge.
Certainly.
Your lordship is
I
sitting
know jurisdiction.
in the jurisdiction, and your lordship knows, I know my limitation also what to argue, my lord. I cannot say something about what the evidence will take place. I cannot, my lord, one argument which is advanced by my learned friend for the informant, that he was saying that no, the two can go simultaneously. What he was saying, one can be left out also. This will depend. He is talking about future, what happens at the time of hearing of charge. No, no, what today I have to satisfy your lordship is of the two sections, whether simultaneously it can go together or not. And that was excellent. There is a fine hairline difference between the criminal breach of trust, what your lordship has indicated. That can be a case of a civil nature also. Sometimes it may happen a criminal nature also. Now, my lord, this is what, my lord, I want to project on this page 54. So it doesn't indicate. So initial deception, what has been taken place, and my learned friend's argument was that it was at Kolkata. My lord, I would rather say that it is not the proposition of law. Initial deception will take place at Dimapur, and thereafter what will happen, that is not the initial deception. So the element of cheating in case of Milan Shah will not arise at all, my lord. At all. Second, my lord. Second.
No element, just
Yes, yes.
cheating. No element of cheating made out according to you against Milan Shah.
Yes.
Okay, yes.
Now, second point, my lord, regarding about the FIR. My lord, there is no entrustment. No entrustment of money to Milan Shah. There has to be an entrustment of money. There is no entrustment of money in this case.
That's clear.
So there is no initial deception, there is no entrust of money. If these two elements are missing, my lord, then, my lord, there is no question of going before a trial court for adjudication of the entire matter. Qua the petitioner, I am only qua the petitioner.
Now, this is one, my lord. Now, going back,
Paragraph 14, my lord, of my note. At page 6. Para 14. It is part, I am not reading the entire, my lord, the notes, my lord. Your lordship, it is between, if your lordship want, I can read the notes.
beautifully put.
Yeah, I can. My lord, it is pertinent to note that respondent number 2 in the FIR has stated, Arun Batori has suppressed the true financial health of his companies and that false and dishonest inducements were made in Dimapur, Nagaland. And your lordship has seen the FIR. I don't have to say now much of what is there in the FIR. Because some assurance was given by Arun Batoria in his capacity, projecting himself as a director of the company, that the true financial health of this company is good. But ultimately they found that, I know, but this project, why your lordship was asking that day, that when I started, that whether the project is completed or not. Whether the project is completed or not. No, that's a very important, not your lordships came to the mind. That is very, very important, pertinent. But why? I have seen one judgment of the Supreme Court. Is exactly on that point. I will show my lord one judgment of the Supreme Court. Then I thought that why your lordship was asking. The point was there that once you invested for a particular purpose and that purpose is complete, and if you can show it is a transaction of a profit, commercial transaction, if it is completed, then it cannot be amount to cheating. It will be only in respect of that remedy is what a civil suit is there. You can go before a civil.
Maybe consumer also.
Yes, right. Absolutely correct, my lord. So where is the question of here? There is misappropriation, my lord. There has to be misappropriation, that's a different. But the question that was, then I have checked some judgment of the Supreme Court on that line. That about whether the project is completed or not, and whether this amounts to cheating or not. Once project is completed, my lord, and it is a commercial transaction, that means the money which has been utilized for that purpose is complete. Now, what you can do, you can go before your lordship, say either civil court or deficiency. These two options are left out. Otherwise, he doesn't have any other option to go for a criminal case against it. Now, this is para 14. Para 15, kindly see, my lord. It is noteworthy the respondent number 2 in his FIR and statement, criminal petition, so has failed to specify how the petitioner cheated him and or how the money was entrusted to him. Moreover, there is no documentary evidence, my lord, very important, demonstrating the petitioner involvement in the alleged transaction. Respondent number 2 allegation, averment against the petitioner is general and vague, merely stating that the petitioner verbally assured him reliance is placed on Sanjay D judgment, my lord. This reliance, all the judgments already we have placed, all the judgment. I don't want to place again, my lord. Next. My lord, now C is very important. Kindly see. Respondent number 2 written objection is an attempt to improve his case. At page 7, my lord.
Yeah.
Page 7. Yes. See, my lord. Now 16. At the outset, it is pertinent to note the respondent number filed his written objection on 1/4/2026. That is, after the petitioner's statement was recorded under section 35(3) of BNSS and petitioner has fully complied with multiple notices under section 34 of the BNSS. 94 and my lord, 94 and 94 we comply. That's what we want to say. 17. Your lordship was asking yesterday that whether you file any application modification variation of this order. Well, because my learned friend PP was present at that relevant time. He said it is not required. They did not file. It is by virtue of the court's order. Sending same notice, my lord. That's why we came to the court. Now, 17, my lord. Respond number 2 in his written objection, para 2F, at page 4, for the first time, averred that Mr. Arun Bhattacharya presented an overview of the project, that is 2 plots of land situated at Behala, Kolkata, on which a multi-story building will be constructed. Further, in para 2G at page 4, he averred that being convinced by the feasibility of the project presented by Mr. Arun Bhattacharya, he agreed to invest in December 2010. To support this statement, in para 2I at page 7, respond number 2 states that the accused person handed over the sanction plan to Mr. Pradeep Agarwal. It is in his written objection before this honorable court that it attempts to portray that this money has been invested in Behala project. Nowhere in the FIR, the money received or his statement to the investing authority does he state that his money was invested in Behala project. My lord, your lordship, as nowhere it has been stated. First time he won to my lord to improve his case by saying that my lord will kindly remember, my lord, I have stated here, I just want to, orally I want to place, my learned friend has said before this court that this particularly, he want to say projection about Milan Shah. My Milan Shah, with his greatest respect, I have statement also was made. He is not night by flight operators, my lord. These are not night by flight operators, my lord. These are, my lord, investor. These are investor. Now my learned friend was saying that he is having some 3 companies. Maybe he may have 100 of company. How we are concerned? These are not my night by flight operators. They are investors. They have 3 companies, my lord. See, please see the profile of this company, my lord. More than 200 employees. 200 employees, my lord. And my lord, I asked my client, my lord, I asked my client, why? You invested, why became? Because to safeguard that money, my lord, I invested my amount. And your lordship will recollect, my learned friend, what he stated, PP stated that he was an investor. That is one of the statement is one Jay asked, my lord, has given a statement, which my learned PP has read this statement before the court. And he stated that he invested. And what I remember yesterday, my lord, he said that he was introduced. This Milan Shah was introduced by that person. And I came to know that he's a broker. He introduced to Bhattacharya's family, my lord. Pradeep Agarwal was not in the scene also. I did not knew who is Pradeep Agarwal. He introduced to Bhattacharya's family. Now they discussed, they said there is a project. And we readily, because we are investor, we do a lot of projects, my lord. 200 employees. So we decided to invest. So we invested huge amount of money in this project, my lord. Not in Behala. There are other projects which we have done. Once the project is over, that my lord, then we came out. We have to safeguard our money, my lord. So that is why we entered into as a director of this company. We were never the shareholder, my lord. We are never a promoter of this company. Bhattacharya are the promoters of this particular company, my lord, of Epcon. And my lord will kindly see what my learned friend wants to connect yesterday. Yesterday he is saying that there is a company named by Ketram Estate, which your lordship will find in his written objection. Please see his written objection. 2Q, my lord, 2Q in the written objection. His written objection, man. 11 Please see page 9 at 2Q. My learned friend was giving an impression to the court. Look here, this is the person. Power of attorney was page 9. And see Q. See 2, 9 and 2Q. Please see 9Q. To execute the project, the petitioner Milan Shah and his partner form an association of project or persons through an agreement dated 24/1/2016. This association of persons is comprised of 9 private limited companies. APCON is one, Swadeshi Apartment, Sunshine Developers, all these 9. My lord, this is, my lord, will kindly see the date here in 2016. Please note the date, my lord. 9 is 2016. Your transaction is 2010. 2014, that money has to be returned back. And you are bringing this story of 2016. This was born later on, my lord, 2016. Now, please see, in association of person, namely Khetram Estate, Mr. Milan A. Shah, the petitioner, and his son, Shivam are the authorized signature, all in all the 9 companies mentioned. Petitioner Mr. Milan A. Shah is the authorized signatory. This fact can be ascertained from a power of attorney executed on 25/4/2018 and deed of mortgage dated 6/7/2019. This document shows petitioner is the attorney for executing the project on the 2 plots of land purchased for the project. Now, how you know that these are the project? Informant didn't knew at that relevant time. Informant was aware that this money has been given for some project. Money received doesn't indicate about Khetram Estate. Money received doesn't instead has indicate about this 9 this association of person forming it.
Next.
And this is what, my lord, kindly see. 6 years, my lord, after money has been taken. 6 years after that money has been taken. So how he is only indicating informant that name of the APCON appears here. If you see at page 9, name APCON properties. So if that be the case, so yes, this is money has to be is invested in the company. And my lord, we is saying that these are public document. Sanction plan is a public document. And who has given the sanction plan? Mr. Pradeep Agarwal has given the sanction plan. Now, this you will find my reply at page 20, my lord, your lordship, please 9 at page 20, my reply.
Your reply.
My reply at page. Apart from note, your lordship can look into it. You don't have to look into it.
Page
From the note.
from the note page.
Para 20, page 8. Para 20, page 8 of my note. Lordship got it? Yes. Para 19, para 20. The case now being projected through his written objection is unsubstantiated. Firstly, my lord, prior to his written objection, respondent number 2 has no idea where his purported money has been invested. Secondly, respondent number 2 has entrusted the money to Mr. Arun Bhattacharya in December 2010, who has promised to return the money with profit by 10/12/2014. Thirdly, there is no basis whatsoever for the claim respondent 2's money has been invested in the Bela project by Khetram Estate. Respondent are attempting to paint a picture by making unsubstantiated statement through which they are projecting. Yet Messrs. APCON Properties Limited, Association of Person, Khetram Estate are one and the same thing. This is what they are trying to project, my lord. The name of APCON comes, that's why I say they are involved. Now, my lord, this is what, my lord, because he was harping on that, on the APCON. Secondly, what he was harping, my learned friend, my lord, this statement of the PP where they relied this statement of the I forget his name, Jay Sachar, my lord. His statement, my lord, if your lordship looks, he introduced to Bhattacharya's family. If your lordship kindly recollect, there was the introduction of Bhattacharya's family by this gentleman who introduced.
What was his name?
Yeah. Yes.
Yes.
He was a broker, my lord. Please note, my lord. He was a broker where, my lord, Milan Shah was introduced to Bhattacharya's family. Pradeep Agarwal nowhere in the scene, Arun Bhattacharya were nowhere in the scene. It is only they discuss about the project. I also decided to invest in the project, my lord. And my lord, he is a man of Mr. Pradeep Agarwal. And strangely enough, Pradeep Agarwal is all this he is doing it, my lord. And my lord will kindly see, why not Pradeep Agarwal is not been made an accused in this case? Why not?
He's a witness. no?
He is a witness. Why witness, my lord? If it is in presence of Pradeep Agarwal and other two directors, why not, my lord, Pradeep Agarwal has not been made an accused in this case? Why he has been left? Please see para 61 of my note. I have a note. Para 61.
60.
Yes, please see. It is pertinent. Para 61. It is pertinent to note.
Yes.
It is pertinent to note the respondent to at very instance had changed the role of Mr. Pradeep Agarwal. In the FIR statement, he has projected as someone who has proposed the real estate investment to respondent to and assured him, along with Mr. Arun Bhattacharya. Whereas in his written objection filed on 1/4/2026 to the instant criminal petition, Pradeep Agarwal was his source of information. Now, in his written note presented to this honorable court, Pradeep Agarwal was the representative of respondent number 2 here in Kolkata. This is what they are stating. Representative of from where he is becomes a representative. Now, my lord will kindly. Now, please see, please, the salient list of dates, my lord. My rebuttal to the informant is at para 20 and 21. 21, please see 21, my lord. My rebuttal against respondent number 2's argument. If I can, lordship, permit me to read.
Page 8.
21 at page 8.
Okay.
Well, I hope so. I am going in sequence. Otherwise, sometimes
No.
I missed the track.
No, it's very convenient.
Aye.
Okay.
It is respectfully submitted. Respondent number 2 alleges that he invested rupees 5 crores in Epcon property in December 2 on the assurance given by Arun Bhattacharya and Pradeep Agarwal, who promised him at 30% profit. He was allegedly assured that the investment along with profit would be returned by 10/12/2014. In other words, he entrusted Mr. Arun Bhattacharya with investing his money on Mrs. Epcon Properties Limited, who assured him of profit and that he would return the money by 10/12/2014. Now, in his written objection, without any basis, he projected as the money was invested in the association of persons who completed the project at Behala. There is no explanation as to how his purported investment made in 2010 to Messrs. Epcon Properties allegedly through Mr. Arun Bhattacharya, who passed away on 18/10/2011, 8/10/2011, flowed into the association of person created on 24/1/2026, whereas 24/1/2026 created, yes, whereas he was supposed to receive his investment back on 2012/2014. It should be 24/1/2016. My lord, your lordship will please correct. I'm sorry, my lord. 2016. 2016, whereas he was supposed to receive the investment back on 10/12/2014 along with profit. So kindly see, my lord, the flow, how it went. My lord, it is next to impossible. In the trial court also, 5 crores, it is matter of joke, my lord. 5 crores could not.
In cash.
I'm sorry, my
And
lord.
that raises his own questions, no doubt.
I'm sorry, my lord.
No, 5 crores in cash transaction raises his own questions.
Correct. Absolutely correct, my lord. Now, my lord, I'll trouble with
No,
that salient list of dates, my lord. They're at page 9. These are the dates where it will be irrelevant. 24/11, Arun resigned as director of Epcon and a petition inducted as a director of Epcon Properties Limited. 10/12/2010, Arun Bhattacharya was introduced to respondent number 2 by Pradeep Agarwal Dimapur. Arun Bhattacharya and Pradeep Agarwal assured respondent 2 about the financial soundness, and he agreed to invest 5 crores for 30% profit. Epcon respondent handed over 1 crore. 17/12/2010, respondent number 2 handed over 4 crores to Arun Bhattacharya at Kolkata. Purported money received issued by Arun Bhattacharya. 8/10/2011, Arun Bhattacharya passed away. 10/12/2014, date on which respondent whose money with profit was to be returned. 24/1/2016, formation of association of person wherein Epcon Properties Limited along with 8 other companies of then 28/4/2023, project at Behala completed. Now, my lord, 22/6/2023, if your lordship please turn to next page. The petitioner resigned from APCON properties, 1110 FIR registered under section so and so. So these are the list. Issues involved in the present criminal petition. A, whether the petitioner is vicariously liable for the act of Arun Bhattacharya, allegedly acting for and on behalf of APCON. Why I made this issue, my
It's
lord?
not interest. Entrustment is not there on the facts. It's not.
I made it. Why, my lord, your lordship?
It's clear for the-
Yesterday, what an argument of my learned friend was he was naming the company. If I am not wrong, he was naming the company APCON. My lord, if I am not wrong, your lordship, please correct me. He was naming the company of APCON. He was saying all this was for and on behalf of APCON.
No.
For and on behalf of APCON, what he was mentioning. And please see what he was, for a moment, if your lord holds it, and see at page 53, 54. See at page 54. Page 54 of criminal petition. Sorry, criminal petitions, my lord. For a moment. He was harping on for and on behalf of AFCON, what he was harping. For and on behalf of AFCON. Please see at page 53.
53.
Is very Arun Kumar Bhattacharya, my lord, on the top is on a letterhead on his letterhead. His own letterhead, Arun Kumar Bhattacharya.
Page 53 of the.
53
Of the
of the
petition.
criminal petition. And type copy is at page 54.
So,
Please see, my lord. Yes. Arun Kumar Bhattacharya at page 53. Lordship will see for APCON Properties Limited, director. Lordship, on below, director, and on the left-hand side, witness Pradeep Agarwal. And if you see, it is only on the letterhead of Arun Kumar Bhattacharya. And if you see the clear copy, please see at page 33 of their objection. It is very clear of their objection. Of their objection which they have filed before the court. The clearer copy objection which they have filed. Page 33. He is harping on for APCON. See page 33, my lord. Please see. This is what you find. See, for APCON Properties Limited. So he was harping on that. It is for and on behalf of the company. This money has been taken. But if you see the reading of the receipt, it is only in respect of Arun Bhattacharya, the money has been handed in presence of Pradeep Agarwal. And what I'm asking, where's the resolution of the company, my lord? There is no resolution of the company. Have we produced any resolution of the company? That this resolution of the company, yes, we have entrusted so and so. So where is that? That this money has been invested for the purpose of the project? Nowhere, nothing. They could not show anything anywhere, my lord. So now, my lord, going back to my written note at page 10, B and C, my lord. B and C, whether the petitioner at B and C. B and C. Whether the petitioner was entrusted with property having domain over the property and the same has been misappropriated or converted for his own use. Now C, whether the petitioner has fraudulently or dishonestly deceived the respondent number 2 to deliver any property and where such dishonest intent petitioner was present at the time of making of the inducement. But this is my junior, he has made always, your lordship will please look into it.
yeah, right.
But I didn't get much of the time to look into it. Hurriedly, I have
I'll go.
look into it, my lord. Your lordship will please look into
I'll
it.
read.
Yes,
Surely.
sorry for troubling for that also. Now, if you see our submission, I don't want, my lord, to read this. My lord, para 22, it is a fit case for this honorable to exercise a jurisdiction under 482 CRPC to quash the FIR dated against the petitioner. 22, My lord, this is 23, kindly see, my lord.
23 of the petition.
20, no, at my argument, note, at page 10, my lord.
Okay.
At page 10.
Yes, I'm here. only.
Yes, submission by the petitioner.
Yes. Got
It is a fit case, so and so.
Got it.
22, my lord. The respond number to so and so. These are all we have said. Number 23 is, my lord, we have shown the judgment. I don't want to repeat again of the Delhi High Court where the money given in cash. Any cogent evidence document will show how the money was arranged and paid. And without any agreement indicating the purpose of such a transaction, does not make a prima facie case for even issuing summons to the accused person. Now 24, my lord, Arsad Nayaz Khan, my lord, we have shown the judgment. What is breach of trust constitute a penal action? I don't want to trouble. 25 also, my lord. 405 and 406. Now, this judgment, my lord, we have not shown the judgment.
I'll find it. No.
Yes.
Take it out.
Yes, please, my lord, this judgment.
I'll take it.
Yeah. And my lord will kindly see Devendra was no, 26. A. Mohan, my lord. In between line. No. A. Mohan, I have shown, my learned friend as well shown. Observe the complaint who initiate or proceed the proceeding being fully aware are unwarranted and that is a civil remedy lies only said proceeding. Should be made accountable at the end of such misconceived criminal proceeding in accordance with while quashing the criminal proceeding, court held a dishonest inducement to enter lacking to attract the provision of section 415, 420 as no role of inducement was attributed to the accused. So here also is the same case, my lord. 27, my lord. Please, my lord will see 27. I just read 27, my lord. On its face, the complainant appears to allege the complainant entitled loan transaction of Arun Bhaturia in his personal capacity for a period of 4 years, where he was promised of 30% profit on his principal amount. Money has been handed over to Arun Bhaturia on 10/12/2010, 7 as evidenced by money received. There is no entrustment. It is a civil dispute on non-payment, purely a commodity transaction given a criminal color. Criminal color, your lordship will please see the footnote, my lord. This all judgment has been referred in the footnote. Now, my lord, we'll see 28, my lord. As a general rule, FIR should be quashed sparingly. However, it is well settled that court should quash FIR to prevent the abuse of process of the court and the misuse of criminal justice system. In the instant criminal petition, respondents failed to demonstrate that the petition entrusted the property domain over the property of respondent, nor was the respondent to induced by the petitioner. Now, para 29, my lord. Mahmood Ali's case, my lord. It is important that when the accused invokes 482 jurisdiction on the ground, FIR on a criminal proceeding are manifestly frivolous or vexatious or instituted with an ulterior motive to vengeance, the court owes a duty to look into the FIR with care, if needed be read between the lines as look into averment made in the FIR may not be enough. Supreme Court drew a fine distinction between the consideration of material tendered as evidence and the appreciation of such evidence. What appears to be permitted is to look into the materials to assess what the complainant has alleged and whether any offense is made out, even if the allegation is accepted in total. Now, 30, my lord. In the present FIR is deliberately drafted in general and vague manner. Therefore, to prevent the abuse of process of court, misuse of criminal justice system, Honorable Court may read between the line to examine whether the allegation in the FIR for the petitioner are substantiated by material, that is money received and the statement of respondent number 2 produced before this court. Now, respondent case B, my lord, is entirely based on general and vague allegation, may merely stating the petitioner verbally assured him. 31, my lord, we refer to a judgment, Sanjay D. Jain. I think we have already placed. I don't want to trouble again, my lord. Please go on anyway. I can please that judgment, my lord. Your lordship can take that.
I'll take it out.
I don't want to read that judgment again, my
I'll
lord.
take it out.
Yes. And 32 also, my lord, Ashok Kumar Jain, my lord. All about the allegation FIR when it can be questioned, my lord. Now 33, my lord. Gauhati High Court judgment, my lord. I have shown the judgment. So now 34, my lord. Delay. My lord, this is important. 34, my lord.
Yes.
There was, my lord, my learned friend could not explain why there is a delay. He was saying about COVID, my lord, pandemic. When the pandemic, my lord, 2020, March 2020, but your FIR was somewhere in 2025, right? And your transaction was 2010. So you said that returned money in 2014. From 14 to 20, what you have done. So there is no explanation of delay in this case. And my lord, very important, please note, my lord, there is no email, there is no WhatsApp by the informant, there is neither, not even a letter also, my lord.
By informant.
Yes, my lord, my learned friend, PP, if he could have produced any letter prior to 2014, either to my lord, because what is stated that he went to the company and in presence of Pradeep Agarwal and three other witnesses, three other director of the company. Why then, my lord, he knew the address? Why he could not produce any letter? Why not an email? Not an email, not even a letter, no document. Because my learned friend could not produce anything before the court. Your lordship, of course, has to look into it. But what he read, my lord, there was no letter whatsoever, my lord. No. Now, my lord, will kindly see at 34, noted that this is about 8 years delay. He could not explain. Now, 35, there is a long delay in filing. The money with profit was supposed to be returned within 4 years. 10-12, we explained, my lord. 10-12-2014. GG entry is dated 7-1-2023. That is after 8 years. FIR is dated 11-10-2020. That is nearly 11 years. There is nothing specific in the petition other than vague allegation. No dishonest or fraudulent representation at the outset. Complaint, instead of availing civil remedies, is attempting to misuse the criminal justice machinery. Therefore, the petition respondent to allegation averment against the general and vague, merely stating the petition verbally assured him. That's the only statement. Verbally assured him. Now, 36, respondent who purportedly entered into loan agreement with so-and-so, allegedly acting on behalf of AFCON in December 10 for a period of 4 years, that is 10-12-2014, has failed to justify reason for such a long delay and made only vague allegation that the petitioner purportedly, verbally, would be repaid along with profit. There is not even a single document respondent who has produced to substantiate his vague allegation. Otherwise, why the informant has not filed in a written objection, my lord? These are what the email was sent. No, nothing. Now, my lord, see, my lord, how the entrustment, I don't want to and have never entrusted domain over the property. These are our judgment, my lord. 37, 38, 39, my lord. Then number D, my lord, at page 17. No inducement by the petitioner at any moment in time. At page 17, my lord. If you see on the top, my lord, there is no inducement by petition at any moment of time. Nagaland, these are all the judgments which has been quoted and cited, my lord. So all this goes on, my lord. And my lord, up to page 46, my lord. Now, E, my lord. Please see 19. Now, hardly 3, not much, my lord. E, my lord. The petitioner cannot be vicariously liable for the action of Mr. Arun Bhatoria. Respondent projecting a case of Arun Bhatoria dishonesty induce him to invest 5 crores in so and so. Therefore, if the respondent is alleging petitioner, well, because he was director of EPCON, then the company would purportedly took his money, should have been made a party. Petitioner cannot be vicariously liable for Arun Bhatoria. Now, penal code, except for some provision, my lord, this is important, my lord, at para 48, does not contemplate any vicarious liability.
Unless it is provided by law.
Absolutely. I don't.
Intention,
Now,
conspiracy.
well, I will not read this because your lordship has said about this. Now, see the judgment. These are judgment and detail. See one judgment, my lord. This I have not placed, my lord. This is rebuttal, I want to place it. Please see the judgment at para 16 to 22, my lord. 16 to 20, my lord. Regarding about vicarious liability not applicable in penal code. Statute has to provide to attract section.
Yes,
Oh, yes, that's what the law says.
16 to 20.
Para 19, my lord. 19, please important, 19. 19, yes. Please see 19, my lord. As admitted, if drafts were drawn in the name of the company, even if the appellant was his managing director, he cannot be said to have committed an offense under section 406 of Penal Code. If and when a statute contains creation of such a legal fiction, it provides specifically, therefore, in absence of any provision laid down under the statute, a director of a company or an employee cannot be held to be vicarious liable for any offense committed by the company itself. Now see 20. We may in this regard notice the provision of Essential Commodities Act, Negotiable Instrument Act, the Employees Provident Fund, Miscellaneous Provision Act have created such vicarious liability. It is interesting to note that section 14A of so and so creates an offense of criminal breach of trust in respect to amount deducted from the employed by company in terms of the expense appended to so and so. A legal fiction has been created to the effect employer shall be deemed to have committed an offense of criminal breach of trust, where a person is charged of the affairs of the company and in control thereof has been made vicarious liable for the offense committed by the company. But even in the case falling under section 406 of the Penal Code, vicarious liability has been held to be not extendable to the directors or officer of the company. It cannot be extended.
Committed by company.
Yes, right. So now, one judgment, Sanjay Dutt and others, my lord. Para 8, 11, 8, 11 to 14 and 17. My lord, please note, para 8 is the role of all the companies. What was the role of all the directors? Para 8. 8 to 8, comma 11 to 14. Law laid down by the Supreme Court.
11 to 14.
11 to 14. 17 is the conclusion, my lord. And 8 is the role. What is the role of the company? If you see at para 11, my lord, that's a law.
17 is the conclusion.
Please see 17 conclusion.
I'll see 11 now.
No, please see 11, my lord. It appears that the courts below proceeded on the erroneous assumption that the three appellants have been responsible officers of the company are liable for a alleged offense. While a company may be held liable for the wrongful act of his employee, the liability of his director is not automatic. It depends on specific circumstances, particularly the interplay between the director's personal action and the company's responsibility. A director may be vicariously liable only if the company itself is liable for the first place, and if such director personally acted, my lord, please note down, in a manner that directly connects the conduct to the company's liability, mere authorization of an act at the behest of the company or the exercise of a supervisory role over certain action or activities of a company is not enough to render a director vicarious liability. There must exist something to show that such action of the director stemmed from their personal involvement and arose from the actions or conduct falling outside the scope of his routine corporate duties. Thus, where the company is the offender, vicarious liability of the statutory provision or to this effect, there has to be a specific act attributed to a director or any other person allegedly in control and management of the company. To that effect, such person was responsible for the act committed by or on behalf of the company. My lord, kindly see, if it is for on behalf of the company, you don't make a company as a party, then only liable will be this Arun Bhattacharya who died. He acted in his personal, if at all he was the director of the company. We are saying that he is not a director of the company. If at all he would have been director of the company, personal liability will be only in respect of Arun Bhattacharya, not in respect of the other directors of the company. Whatever you have done, may have done as a director, but other will not be responsible unless you don't make as a company as a part. Now, para 12, my lord. At some same time, wherever by legal fiction of the principle of vicarious liability attracted, and a person is otherwise not personally involved in the commission of the offence is made liable for the same, it has to be specifically provided in the statute concerned when it comes to penal provision. Vicarious liability of the managing director would arise provided any provision exists in that behalf in the statute, even when such provision or for fastening vicarious liability exists, it does not mean that any and all directors of the company would be automatically liable for any contravention of such statute. Vicarious liability would arise only if there are specific substantiated allegation attributing a particular role or conduct to such director, sufficient enough to attract the provision constituting vicarious liability and by extension the offence itself. It is not 13, my lord. It is a cardinal principle of criminal jurisprudence. There is no vicarious liability unless the statute specifically provide. Thus an individual who has perpetrated the commission of an offence on behalf of the company can be made an accused. If the statute provides for such liability and there is sufficient evidence of his active role coupled with so and so, so and so, so and so, primary responsibility is on the complainant to make specific averment required under the law in the complaint so as to make the accused vicarious liability. For fastening criminal liability or on an officer of a company, there is no presumption that every officer of a company knows about the transaction in question. That's what the judgment, my lord, with these two judgments. And the company also not made a party. If you are saying all the time harping, company, why you did not make company? You know the company cannot be made a party because statute doesn't provide. Para 9, 11, 13. Paragraph 9, 11, 13. No, my lord, if you see the help, my lord, head note, my lord, please see the help. Head note. Though the allegation are against the company has not been made a party, therefore the allegation restricted to managing director, allegation are vague and in fact, same are principally leveled against the company. There is no specific allegation against the managing.
So when the company is alleged to have committed an offence.
Yes, right.
Like in share
That's-
foundation, whatever.
Correct, my lord.
Anyways.
Absolutely right.
Then
My lord, this goes, my lord. Now one very important matter which he was arguing the matter before the court, that there is a suppression. If you see the objection, my lord, my petition for a moment, see my petition for a moment, my lord. What my learned friend want to say about the resignation of the Arun Batorian.
your petition, I am taking.
Yes, please
Page?
see my petition
Page?
at page 55. They said that there is a suppression. We have not annexed all the documents.
Page 55.
55 of my petition. Ministry of Corporate Affairs. If your lordship looks into it, it is 29/11/2025. 10 minutes over the moment. Within 5-10 minutes, I'll conclude. my lord.
Yeah, please repeat. the page.
Please see 55,
55, sir.
29/11/2025.
Yes.
Lordship got it?
Mm.
Yes, please see, this is what we have annexed this. This is Ministry of Corporate Affairs. See name of the director, designated partner Arun Batoria. On the top, my lord, details. Yes. Now please turn to next page. Page 56. See 18, my lord. 18. Last. Director. Now please see EPCON, the name of the company. Date of is that 24/11/2010 you resigned. Date of this is. So the money which you negotiated is on 17/10/12/2010 and 17/12/2010. You are not the director of the company. This is what our argument was, my lord. So if you are not a director, how you projected yourself as a director of this company? Now, this was our argument. So he cannot be a director of the company also. Now, let us see their objection. Why he says suppression of material fact, my lord. Please see their objection at page 49. Their objection, my lord. The informant objection. Please see 49. See form 32, my lord. Page 49. Now what my learned friend managing director or director of the company is Sandeep Batoria, A3. Lordship got it? Now, please turn to next page at page 50. Now see Milan Ajit Kumar Shah, which is the petition on top. Now appointment kindly see as a director. See on the right hand side of the column 24/11/2010. The day when my lord Arun Batoria resigned from the company, I came into in this picture. 24/11/2010. Lordship got it? Now, what my learned friend was saying, now if you say turn to page 51, please see page 51. Top name Arun Batoria, who has taken that money. Now, hereby confirm, above mentioned is not associated, last is not associated with the company with effect from 24/11/2010.
Where?
My lord, at page 51, last line. Hereby confirm, top is my Arun Batoria on top. Kindly see, hereby confirm above mentioned, that is my lord, he was the director. That mark is given, is not associated with the company with effect from 24/11/2010. So, my lord, what our argument was that he was not a director of the company. He resigned. Money which was parted was on 10/12 and 17/12. So how they can say all the time that it was director, he was all for on behalf of the company. Now, why is saying separation of material fact? Please see 52, page 53, my lord. With this 3-page, 52 and 53 has not been, we have not annexed that. We have not given this. Because that is not required. Well, I will show that law is not, doesn't require. 52 and 53, please see. What is the argument at page 53, my lord? These two documents, 52 and 53. Because if you see this, my lord, at page 50, please say 50, my lord, again. I'm troubling again 49. 49, please mark, my lord, 49.
Of the written object.
Oh, no, written object, page 49. If you see down below page 1 of 5, that means 1, 2, 3, 4, 5. Right, my lord? Now, page 53, please see 53. That certificate on the down below. It is ever certificate. I have verified the above particulars so from record, EPCON, official e-form filing date is 21/12/2010. So he is what is saying, my lord, he is saying that the effective date will be on 21/12/2010. Only holding of the name of the company by which he has, my lord, resigned. Entire holding of the company will change only on 21/12/2010. Now, my lord, let us accept his argument. Let us say the holding of the company changed only on 21/12/2010. That Mr. Milan Shah, while he entered into this company, was also, please see at page 50. Please see their objection itself, page 50. Please see page 50. When Milan Shah was inducted as a director, please see 24/11/2010. Lordship got it?
Okay.
And he resigned from the company also 24/11/2010, where your Lordship will find from our resignation. His resignation will kindly see at page 51. Please see 51. Arun Batoria resignation. Cessation, my lord, please see. Please see the third statement to assess. Please see Arun Batoria, 51 cessation. There's a mark at page 51. Arun Batoria on top, cessation. Now, hereby confirm is on 24/11/2010. If your argument is to be accepted and you say from edit, it from filing of this, it is uploaded in the portal 24/12/2010, then I was also not a director of the company. What statement? Statement to disseminate. Who doesn't? My lord, I have given in my written note at page 50, page 21, please see my written note. Oh, wait a second, my written note. See my written note, my lord, at page para 53.
Para
53, my lord, at my written note at page 21.
21.
Page 21, para 53.
Just a Okay.
Assuming without admitting that the stand taken by respondent is true and correct, that the date on which Form 32 is filed is to be taken as the date from which the change in the holding of a company is to be considered, petitioner would also not be considered a director until 21/12/2010. The to the same Form 32 filing. If I take your argument also, my lord, then also I was not inducted as a managing director, as a director of the company. Now see 54. However, the settled position is that resignation takes effect immediately upon the intention to resign being made clear. Mr. Arun Bhatia resigned from EPCON on 24/11/2010. A director can tender his resignation unilaterally without completing Form 32 or sending a notice to the register of company. This is my judgment of the Supreme Court. So the advancement of the argument by my learned friend, with great respect, is wrong, my lord. You see, Bombay High Court judgment, my lord. A division bench judgment of Bombay High Court. So the argument that has been advanced that it will be on the load on the uploaded in the e-portal, that is absolutely incorrect law. 6 and 7, please note, my lord, paragraph 6 and 7. 6 and 7, your lordship can look into 6 and 7. It says once you resign, tender resign, that is absolutely, that has to be from the date it is being given effect. Huh? No, you can ask me. My lord, large judgment. You want your lordship want to read this judgment?
No, this one.
Yes. Yes.
So, I'll-
A paragraph, my lord.
No, so, no.
6, 6 and 7.
This is regarding director.
6 and 7.
Yes. Yes.
Now, my lord, one last judgment.
Okay.
See para 44 of the note. Para 44 of the note. I think it is most
Para
44 of my note. That is page 18.
No, this judgment.
Yes, the judgment is, my lord, para 7, 13, 15, 16 and 17. I kept the judgment. I thought that I'll give a rebuttal in the judgment. So please see para 44, my lord, of my written note. It is page 18, para 44 of written note, my lord. Written note.
What?
Written note. See
Para
page
18.
para 44, my page 18. Page 18. Recently, V. Ganeshan versus State, the Honorable Supreme Court held that if the case of the complaint is that his money was taken and invested in a project which has been completed and is denied profit, and the principal, then it cannot be a case of false and dishonest intention, inducement promise at the time of making a promise. I think what your lordship is trying to get one hold of a judgment that once it is completed, my lord will please see this, my paragraph. Please see para 7, my lord. Para 7 of the judgment. Now I'm taking to the judgment, which is almost similar to our case, my lord. Para 7. Please see para 7, my lord. Para 7. Of B. P. Ganesh.
This was quashing of FIR.
Yes. Question of an FIR. Question on FIR. On behalf of the appellant, it is submitted, para 7. It is submitted, admittedly, the second respondent invested money in a movie project on expectation of good return. There is no dispute that a movie project was completed. However, it could not generate profit. In such circumstances, the appellant could not fulfill his commitment of providing good returns on the investment. Therefore, there was no dishonest intention, and the dispute between the parties is purely civil in nature. And institution and continuation of criminal proceeding is nothing but abuse of process of law. Now, you'll see at paragraph 15. No? Please see 13, my lord. Para 13. Para 13. In order to constitute an offense of cheating, the intention to deceive should be in existence when
what
the
said.
inducement was made. Lordship, para 11. Yes. Para 11, please see, my lord. I will not read. Now, this is important. Para 11. The above extract makes it clear High Court was of the view that the money was advanced on a promise of good return, and subsequent undertaking was also given to return the principal amount if the profit did not yield any profit. Project did not yield any project. It could be taken that the complainant parted with his money on the inducement of the appellant, and therefore, prima facie, an offense punishable under Section 420 IPC is made out. So High Court quashed only 406, my lord. The High Court did not quash 420 in this case. Then Supreme Court, my lord, what the Supreme Court said, my lord, is please see paragraph 15, my lord. Whether please see paragraph 15. Whether non-fulfillment.
In this case, charge sheet was submitted.
Yes.
Charge sheet was submitted. Not FIR.
Whether non-fulfillment.
Anyway,
Yes.
so
Whether non-fulfillment of promise commitment by the accused is a reflection of his or dishonest intention at the time of making the promise or in the matter of trial. However, in our view, where the transaction with the party is such that fulfillment of the promise is not entirely in the control of the promisor, or there is an inherent risk in the fulfillment of promise, the High Court may, in exercise of the inherent power under court, or Article 226 of the Constitution, as the case may be upon consideration of the attending circumstances, takes a decision whether the dishonest intention existed or not at the time of making the promise. And if it comes to the conclusion that the alleged conduct of the party does not reflect a dishonest intention of the accused from the view of beginning, it may quash the criminal complaint proceeding and relegate similar remedies. Just give me 2 minutes.
no. Take it. Have some water. Yeah, I can take a break also. Please take a break.
Yeah.
Take a break. Continuously with him. Please take.
Yes.
Take some rest.
This is also this. You can ask a glass of warm water to eat. But I think we almost done with it. Warm water from the
So 5 minutes.
Are you comfortable?
Yes, yes. My lord, please see the last
It's
paragraph.
the way, now earlier we used to pat on the back.
Yes.
Hold this. Yeah,
Yes.
it's very effective.
Yes, sir.
Very, very effective. This,
Oh.
this pulse, no? When you have a, what is called? Anyway,
Paragraph 19, my lord, last paragraph.
paragraph 19.
19. In the instant case,
Yeah, from.
para 19 of the judgment. Judgment which your lordship
Oh,
was
yes,
reading the
19,
judgment.
yes.
19.
Para 19.
This is important. In the instant case, there is nothing to indicate that the appellant had a dishonest intention from the very beginning. Had it been a case where the appellant had not made the movie despite borrowing funds to make one, an inference about existence of a dishonest intention was permissible. However, here there is no allegation that movie was not made. Rather, it was made and released. The prosecution case itself is to effect that further advance was taken to complete release the movie. However, when complaint took objection to release, the appellant issued post-dated check so and so where to discharge existing. That's a different existing. But now, my lord, will kindly see para 20, last 3 lines. In conclusion, last 2 lines. In conclusion, the allegation only disclosed a civil cause of action and a High Court fell in error in not questioning the criminal proceeding.
This judgment is relevant to our facts.
Yes, and one paragraph 17. Please see para 17.
The same judgment.
Same judgment. In the middle. Since, my lord. My lord, see the para 17.
Got it.
1, 2, 3, 4, 5, 6. Since there is no denial about the completion of movie and its ultimate release, what is clear is that the promise to make a movie was not false. Therefore, it cannot be said the appellant made a false promise that he would make a movie with aid of funds received by him. In so far as promise qua sharing or profit is concerned, there are no allegation of moving earned profits. Therefore, from the allegation in the complaint, it cannot be said there was any dishonest intention of appellant in making the promises remain unfulfilled. In our view, High Court overlooked that movie make a high-rise business. So this is what your Lordship was putting a query that whether it was completed or not, project has been completed. My Lord, this can be a case, good case for the person who died. If Arun Bhattacharya would have been alive and there would have been a case, he would have been the main accused, even then he would have been a case. As per my Lord, that's what my argument is, my Lord. For my Lord, the person who died, Arun Bhattacharya, he has taken, tomorrow if he would have come for questioning and he would have taken this, I am not remotely connected also. Now, my Lord, this is what. Please see para 63 of my note, last my ending. Para 63, my Lord.
Of the note.
Of my note. This is very important. What was happening in Nagaland, how, my Lord, all these cases are being filed. Now there is a restriction. Please see para 63. I'll read this para 63. It is important to bring notice before this honorable court. The press release titled Nagaland Police issues strict guidelines. Very, very important, my Lord. Strict guidelines. No PIRs in FIRs in purely civil, it is FIR, in purely civil or commercial dispute. Public advice to use civil remedy dated 11/6/2026 issued by the Office of the Director General of Police Nagaland, Kohima. Directive taking note of a series of judgment and directive of Honorable Supreme Court to prevent the misuse of criminal law for settling civil and commercial matters states police station will no longer register FIR in dispute relating to mere non-payment of dues, breach of contract, or failure to repay loan in ordinary business. And as this does not constitute cheating or criminal breach of trust, there should be a clear evidence of dishonest or fraudulent intent right at the inception of transaction.
That means police has to take a call also.
Yes, right.
Otherwise,
My Lord,
whether dishonest intention is present or not is also a subject of investigation. So, but the police has to take an initial call. Actually, that's good also in a way.
my Lord,
That recklessly, if every breach of contract comes as a police case, then the criminal justice system will be unnecessarily burdened. So they should do some kind of a preliminary inquiry, maybe. Some kind of a preliminary inquiry. The spirit of this notification is good.
my Lord, this we have annexed. My Lord, please see the
We'll
note.
have a-
Please see the note. Last, my Lord, annexures.
Okay, this one.
Yes, this is the press release, my Lord.
This should be an,
My Lord, these are, my Lord, why? My Lord, these are happening. That's why they thought. Because you see, my Lord, wastage of the system, my Lord, wastage of the proceeding, court proceeding, my Lord. Party definitely, when these are type of cases are being filed, party will definitely, my Lord, will redress their grievance. Where they will go, my Lord? They have to come before a court only. Now, this is good they have done it, my Lord, press release. As if there will be check and balance, my Lord.
No.
Otherwise, there will be no check and balance. I think, my Lord, enough time was granted by the court. I am deeply obliged for giving such much amount of time to us, only not for 3 days time has been granted to us, my Lord, to complete the argument, my Lord.
can you call?
So, my Lord, the ultimate conclusion is that there is no case which has been made out against the quasi petitioner. There is no ingredients of 409 mile agent, same that breach of trust, and neither 120p cannot be attracted because of the charging section. If that cannot be, you cannot bring out home at a charging section. There is no question of 120p. No case. No cheating has been, my Lord. Also, we don't find any cheating, my Lord, so far as quasi petitioner is concerned. Then, my Lord, if it is in the name of the company, you did not make company as a party. If you have taken money for on behalf of the company, it is you will be liable separately, maybe as a director, not the company. And company, my Lord, because why they have given 409, please see 409. Because they are agent, my Lord, 409.
Yeah. Agent.
Agent.
Breach of trust by agent.
Yes, correct, my Lord. But
Okay,
so Book. See, IPC. IPC 409. Same, whoever being in any manner entrusted with property or with a domain over property in capacity of public service, any of his business or banker, merchant, agent, attorney or agent commits criminal breach of inspector of property shall be punished with so and so. So domain of the property, if he has done of his own, claiming to be director of the company, then he will be liable as per judgment of the Supreme Court.
Anyway,
Yes. Well, all these doesn't attract, my lord, quad a petitioner, my lord, to go for a trial. With great respect, I will say this is a fit case.
no, not go for a trial. Your contention is that it should not go for further investigation.
I am absolutely.
Trial would be if it
Yes.
is charged or final.
Right. Further investigation of the case. Your lordship has put in a better way, my lord.
No.
Further
Question of
investigation.
fact.
Yes, that's why. Question. of
The remaining investigation.
Yes.
Anyway, you have fine this. We'll close it.
And my lord, there is judgment of the Supreme Court also. If necessary, we'll send it by mail, my lord. To your that recently there is judgment. Even my lord, the Supreme Court at a nation stage also, my lord, it can be questioned under 482. We'll send it by mail, my lord.
If it does not make out any offense.
Yes, correct, my lord. There is no question.
Accepted in its entirety does not make out any.
Absolutely correct.
Then it can be quashed. If the allegations accepted do not make out any offense, then it can be accepted. Then it should not be registered also.
Yes.
But if it makes out, then you have to proceed and find out, collect material. I'll see everything. I'll see. That is why the standard of pushing an FIR is high.
That's right, absolutely.
Once charge sheet is filed, you have a complete picture of the materials collected by investigation. But at the stage of investigation, it's an emerging situation. Today something has emerged. You never know what will emerge tomorrow. So whatever materials is before, if it is a case of no offenses made out on allegations, then it's all. I will see everything. I will see it.
I'm deeply obliged.
He does not likely that stuff. Also, counsel for response number 2 and PP for the state addresses further arguments by your reply. The matter arguments concluded. Judgment is resolved.
There is an interim order which will continue.
Interim orders are continued till the pronouncement of judgment.
I am so deeply obliged, my
No
lord.
problem. I'll try to give it
Deeply obliged, my lord.
shortly.
Yes, sir.
Possible.
For orders,
Yes.
item number.
If you want the judgment of that nation stage, my lord, your lordship, yes, we can say.
Give me the name, we'll take it up.
Yes.
Give me the name.
Yes.
Just hold it up. Hold it up.
Yeah.
No, this one is much.
I'll take your lordship,
Oh, yeah,
my lord.
please.
I'll take it.
Hold it up so that it does not get mixed up. Give it a separate testament. Yeah, Joe, just to know. This one first. Just a moment. Yeah, it's possible.
For orders, item number 12.
Yes, please.
May I please, Lordship? Lordship, I'm appearing on behalf of Mr. Senior, Mr. Laknyapom. Lordship, service upon respondent number 1 is still awaited in this matter. So if the matter could be
Is it-
listed after vacation.
Third, Mr. Your good name? Learned counsel for the appellant. Full stop. It is submitted that service report upon respond number 4,
Respondent number 1.
sorry, respond number 1. Who was the claimant in the proceeding before the learned tribunal is still awaited. What about other two, R2 and R3? It is
It's still awaited, Lordship.
still awaited. So respond number 2 and 3 are the driver and owner respectively of the concerned vehicle, in bracket Bolero. Full stop. Their service reports are also awaited. This is the matter after
After vacation.
after 4 weeks. After 4 weeks.
Much obliged, Lordship.
For orders, item number 13.
One we had kept for time being, no? Mr. Devnath is not appearing. One we had kept as a part time being. I think he has some issues with motion. The call it. I think, the call it or we leave a date on Monday. Yes, madam, you are appearing in this. You are appearing in this, madam? You are appearing. Mr. Devnath's matter, I think maybe he's having some difficulty to do.
Yes, Your Lordship, there's some technical problem, it seems.
Okay,
Yeah,
well, let us fix it next week.
okay.
Okay.
Your Lordship.
Full stop. It is submitted on behalf of Mr. V. Devnath, learned counsel for the insurance company that is facing some technical difficulties in joining the proceedings online from Dimapur, I guess,
Yes,
from
Lord.
Dimapur, full stop. List the matter. You can suggest a date if you want.
Lordship, any date? Anything?
Next week or thereafter? Next week or thereafter? This week? Or let's fix it on 30. 30. It's 306, 30th June. Right. So in the motion also, I think we can pass a similar
Yes,
order. No? Just give me the motion also. Supply motion, item 23. Just give me. You can take it down. No? Same kind of order. We'll fix it on the same day.
Yes, Your Lordship.
Same day. Item 23. So, motion. Same order. Same kind of order.
Okay.
For order, item number 15.
May I please, Your Lordship? Lordship, as per office note dated 12/6/2026, await service report upon respondent number 4.
4.
Yes, Your Lordship.
Others
But,
been served. Let's check it.
No, wait, office note. Lordship, on the last order dated 25/5/2026, the respondent number 4 is not the necessary party, so the matter may be proceed.
Right.
Lordship, there was the last para of order dated 25/5/2026.
Last page, yes,
Yes.
to appear.
Yes.
Then we can proceed. That's what he's
Okay.
saying. Well, the other respondents have appeared.
Yes, Lordship.
You have appeared.
I have.
For 1, 2, 3.
Yes, Lordship.
Your madam, what you, you would do this.
Yakırlı.
Learned counsel for the appellant insurance company. Submits that service report upon respond number 4 is awaited and also draws attention to the previous order dated 25/5/2026, where it is mentioned that R4 was to appear on next day. The matter shall proceed first. The learned counsel submits that R4 respond number 4 is not a necessary party. Learned counsel, the respond number 1, 2, 3, being the claimants,
Yes.
are represented by learned counsel. So, Uh, And what else? This is for,
Lordship,
Yeah.
yes,
Are you
the
sure?
matter may be listed after vacation for.
okay, the TCR has come. Case record has come,
No.
then we have to get the case record. Yeah, it has not been called. Call for the original TCR of is it workman's compensation matter?
Yes, your Lordship.
Compensation case number 2/2022 from the Forum of Learned Member Labor Commission. Come employees from the court of the Labor Commissioner, come Employees Compensation Commissioner, Kohima, Nagaland. Good stuff. There's a delay condonation.
Yes,
It's
your
for
Lordship.
delay condonation.
Yeah.
I see. That's why it has not been called. That's why, then it is not necessary now. Let the appeal be admitted,
Yes.
then we can call. That's why it has not been called.
Yes.
Just cut this. Just cut this. So when should we hear the delay condonation? After vacation?
Yes, after vacation.
The IA is by way of condonation of 511 days. But in preferring the appeal by the insurance company against judgment and order dated 7/12/2023 passed by the Labor Commissioner come Employees Compensation Commissioner, Kohima. In compensation case number 2/22. Then you can take it from the angles. Both the learned councils seek posting after the vacation. Prayer is allowed, list after 4 weeks.
For orders, item number 16.
Similar thing. R2 is, you can proceed without R2. Similar thing has been mentioned here also. Service report awaited.
No, your Lordship, for the claimant respondent is already present, your Lordship. Yes.
No, R2 it's still awaited.
But if, as per the previous order dated.
Yes,
Five
yes,
five.
very
yes,
similar.
your
So
Lordship.
that's what heard, Mr. Learned Counsel for petitioner and for respond number 1/claimant.
Yes.
Full stop. My attention has been drawn to order dated 25/5/26 with regard to respond number 2/owner of the vehicle that yeah, that on the next day, if there is no appearance on the next day, the matter shall proceed in his absence. Full stop. Service is still not, service report still awaited from respond number 2. Full stop. With the consent of both learned counsels of both the sides. The matter is decided to be proceeded with. Full stop. When?
After vacation.
After vacation. The IA is by similar 211 days. 211 days. Preferring the appeal. List after 4 weeks.
Your Lordship.
For orders, item number 19.
Lordship, here on the last occasion, 3 weeks was granted to the state respondents for filing compliance affidavit on their own prayer, my lord.
Just a minute. Order dated 25. How many respondents? 3 respondents.
3 respondents.
You are representing?
Lordship, Mohammed is representing for all the respondents.
All respondents.
I believe Mohammed is representing respondents 2 and 3. Pichanu is representing respondent number 1.
Oh,
If sometime maybe.
you take it from the previous order.
The main respondent is respondents 2 and 3. My
Oh,
lord. Yes.
It is submitted on behalf of Mr. Lemchen that due to some personal difficulties, he could not come today. He could not appear to the first. The said learned counsel was to take some instructions, including filing on compliance affidavit in terms of order dated 26/5/2026. The learned counsel for the petition submits that the respondent number 2 and 3 are the main respondents vis-a-vis the compliance of the order. Compliance of the order dated 18/7/25, passed in WPC 337 of 2020. Full stop. We'll post it,
Next week, my lord.
list the matter next Thursday.
Next Thursday, my lord.
List the matter on next Thursday will be 25. List the matter
Well.
on 25/6.
My lord.
For hearing, item number 20.
This is a state revision. State revision. Who's for the other side? Please.
Lordship, I am appearing for the
Okay.
sole respondent. Yes, my lord.
So-
It's a pro bono case. It's a pro bono case.
Okay, that's good. I appreciate. I'll do some pro bono work. Okay,
May I please your lordship?
just a minute. The state is, prosecution is agreed by the discharge.
Lordship, lordship.
You can go. Take some time. Yes.
May I please your lordship? Lordship, the present revision petition was filed by the state respondent by the appellant, lordship. We are assigning the order dated 3/10/2024, passed by the learned CJM Kohima, lordship. In the IA 90/2024. Lordship, which is at page 34, annexure 1, lordship. The respondent has filed an IA 90/2024, and which is arising out of GR number 1/79/2012, lordship. And relevant portion will be at page 46,
36.
46,
46.
para 32. I will only read the relevant portion.
Yes.
Page 46, relevant portion 32. Para 32. As such, upon considering the police report and the accompanying materials and after considering the submissions of both parties, this court considers the charges against the appellant under section 409, 420, 471, 120B IPC to be groundless and deem it fit to discharge the accused person / appellant as there are no grounds for presuming the commission of the offense under the above mentioned charges. 33, accordingly, the accused person, appellant so and so, is discharged of liabilities of the charges mentioned above. Lordship. So we are agreed by the order passed by the learned CJM Kohima, lordship,
Right.
by discharging the petition. The brief of the case in the nutshell is that, lordship.
Let's see the FIR.
The fire
Final.
is at page 48. Page 48.
Written complaint. We have to see the written complaint.
Okay.
Okay, written complaint. This is the FIR form. Well, I mean, I want to see what are the allegations. Then we can read the narration in the charge sheet.
Lordship.
So these are two.
Chart sheet is page 52, Lordship. Page starting from page 50, starting from page 54, 52, Lordship.
Yes. This is what we have to see.
Lord. This is a chart sheet. Brief of the case. If I'm allowed to continue. Page 50.
Yes.
Brief of the case. The prosecution story of the case is that on 31/7/2012, a written suo motu complaint was lodged by Sri Kevoto Mero IPS DIG headquarters PHQ, Kohima, regarding false pension claims in respect of 26 personnel. The 26 personnel belong to 4 units, namely 3rd NAP, 6th NAP, and 7th NAP and DF Tengsang, wherein alleged that their service books were fraudulently entered and pension papers were processed from the PHQ and forwarded to the AG office Nagaland Kohima. The pension cases which were forwarded to AG office was detected as suspicious, and it was further confirmed that their respective units that they had never forwarded the pension cases from their respective units. Upon detection of these anomalies, Sri so-and-so IPS, the then DIG headquarters, lodged an FIR in this regard. On receipt of the so motu complaint, State Crime Police Station, in short SCPS, has registered regular case by the SSP so-and-so under section so-and-so dated 31/7/20 of Lordship. And 16.2 are the particulars, claim of retirement and claim relief. Lordship, 16.3, accordingly, PHQ Kohima constituted 6-member SIT white order so-and-so dated so-and-so for causing throughout investigation. Again, partial modification order was brought out, reconstituting the present SIT members to expedite the present case investigation white order so-and-so dated 15 June 2021. The newly reconstituted SIT members are so-and-so, so-and-so, so-and-so. 16.4, investigation in different units. Now, third NAP battalion, Tengsang. Investigation in the following 6 personnel from 3rd NAP battalion, Tengsang, revealed that 6 personnel does not exist in the records. Their records were not found in the long registered, and as such, their pension cases were never forwarded from this unit to PHQ. The pension registered for the year 2011 were also thoroughly checked. However, no records were found. The regimental numbers of the personnel mentioned in the service book in question belongs to other personnel as per the official records. The same verified from Havildar so-and-so, so-and-so, whose statement were also recorded, corroborated with findings. The seal and signatures of so-and-so, the then commandant of 3rd NAP Tengsang, was found not matching. Very important, Lordship. The seal and the signature of Sri Tokimong Yengchumar, the then commandant of 3rd NAP Battalion Tengsang, was found not matching with any of the disputed documents as per the record mentioned at 3rd NAP Battalion Office, Lordship. This was the finding, Lordship. And Lordship, from the finding of the DF Tengsang, Lordship, investigation in the following DF Tengsang, investigation in 7 personnel from 3rd NAP Tengsang revealed that 7 personnel, only 1 personnel, namely so-and-so, was found to be appointed in DF Tengsang, but left service on 1991. RO, UPSI Tochichang and Havildar so-and-so were examined, and the statement corroborated with that of the findings. In the process of investigation, so-and-so statement was recorded, and he has stated that he discontinued service at his own decision and he had never pursued for any pension claim, Lordship. And Lordship, 6 NAP battalion lordship. The findings is more or less same lordship.
Is it
Lordship. This is deceit lordship. The finding here
similar?
lordship. This is the finding is more or less same, and moreover lordship 7 NAP Bandari lordship. This is also more or less same lordship. The relevant portion will be the following points are revealed during investigation, as my lordship has got it. A, B, and C. The signature and the seal of the commandant and deputy commandant in the service book do not match up with the ones which they were using at the battalion office so and so. And secondly, B, no official records of the above two persons were found in the long record book. The dispatch number so and so in the dispatch register of the service book in question was actually regarding suspension errors so and so, dated as per the unit record, not as pension order as found in the service book lodging. Now coming to 16.5, actual appointment into service as per record. In the process of investigation, it was revealed that the following personnel were enlisted as appointed on the date and place of appointment as mentioned below lordship. These are the names 1 to 26 lordship. Now coming to 16.6, original units. Upon finding of the original units, place of appointment and above cited personnel, the respective appointing unit were also visited to ascertain the facts of the case. 16.6, TF Dimapur. During the investigation, also lordship, lordship may kindly come to page 57 lordship. I will only read the relevant portion lordship, starting from he remembered.
At page?
Page 57 lordship.
Yeah.
Lordship. I will skip those.
He remembered.
He remembered that they were residing in Sematila, but after T. Zeleng expired, they shifted elsewhere, and after that, he has also heard T. Zeleng wife expired. Further attempt to trace the family members of T. Zeleng proved futile, and no information could be gathered. And this is the finding of the DF Dimapur, and this is the 6.6 is the finding of DF Kohima lordship. In respect to so and so, I have to say, in respect of the above cited 3 personnel, a requisition was also submitted to SP Kohima to produce their service record detail. However, no official record could be made available. Reportedly, some of the records registered long book were destroyed by recent fire that broke out in SP office. Thereby, further information could not be obtained from DF Kohima. As far as DF Kohima is concerned, lordship, due to the fire, lordship, they could not collect the information, lordship. But the above 2 personnel and the said 2 personnel could not be traced despite repeated effort, lordship. This is the finding of the DF Kohima. DF Tengsang lordship. Tengsang lordship. 16.6. During investigation, requisition was also prayed to the Superintendent of Police Tengsang to give the details so and so, the name who were appointed from DF Tengsang unit. Subsequently, so and so was examined and his statement recorded, whereby he stated that they were appointed in the year 1982 and 1983 respectively. In the course of investigation, so and so was traced. The name so and so was traced, and his statement was also recorded. He stated that he was appointed in the year 1983 from Tengsang, but left service in the year 1991 voluntarily, and currently he is working as a farmer. On being questioned about so and so, he stated that he knew him, but he expired, lordship. This is the finding of DF Tengsang, lordship. Now the finding of DF Sinapoto. During interrogation, also examined so and so, and he stated that as per the finding in the official report, both so and so were appointed from DF Sinapoto. However, no further detail was available. All possible efforts were made to trace the above personnel, but could not find them. This is the finding of Sinapoto. Now, DF Pei. During investigation, so and so was examined in respect of so and so, wherein he stated that Xavier Chekasang was appointed from DF Pei. However, he voluntarily left the service as per the report in the process of investigation. So and so was traced, and accordingly, his statement was recorded, wherein he stated that he left service in the year 1990 from DF and is on his own violation, and that he did not pursue for pension. His statement corroborates with that of the official records. Now, the finding of first NAP Battalion Chumbuktima. During the investigation, requisition under so and so was also forwarded to commandant for providing all relevant papers in respect of so and so. At the same time, so and so was also examined whereby his statement corroborates with that of the finding. Though so and so was appointed from the unit on 28/4/1980, he was found to be discharged from service on his request on 1/6/1986. Despite several attempts to trace him, information of his whereabouts could not be found. 16.6, second NAP Battalion Alichan Mokokchun. The appointment detail were appointed from the office of second NAP Battalion. Subsequently, so and so was also examined and his statement was recorded, which corroborated with that of the finding. At the same time, the required detail in respect of 8 personnel who were appointed from their unit was also obtained, and cited attempts to trace the personnel appointed from second NAP were met thoroughly. However, no further information of whereabouts could be obtained. And this is the finding of 5th NAP BN Tech Lodge. Page 59. During the investigation, requisition was also made to the commandant so and so was examined and his statement recorded with that of the finding. At the same time, the required detail personnel who were appointed from the unit were also obtained. It was also ascertained that the personnel had voluntarily left on their own violation, on which one so and so, while he was attached to so and so as bodyguard, he was shot dead by an unknown person in Kohima on 16/10/1996. This is the finding of 5th NAP Battalion Pack. Personnel trace and statement recorded. In the process of investigation, under mentioned personnel were traced and the statement recorded under section 161 CRPC, and they have stated that they have left service at their own violation. Investigation transpired that, and these are the names, Lordship. Serial number starting from serial number 1 to 9, Lordship. 16.8. Investigation transpired that the following personnel were found to have expired after they have left the service voluntarily. The record are duly obtained from the respective unit from where they are appointed, Lordship. Now, Lordship, 16.9, Lordship. And these are the names, serial number 1 to 5. Now 16.9. Investigation has transpired that the documents in question relating to the above cited personnel were found all forged, very important, Lordship, all forged, and was never forwarded from the respective unit as mentioned in the documents. Further, the entries made in the service books, signature, and the seal of the units were also found to have been forged, Lordship. Lordship, this is the finding, Lordship, from all the units, Lordship. From the investigation, it appears that the unit have never sent it to the PHQ, Lordship. Now, Lordship, coming to 16.10 PHQ Kohima. In the course of investigation, the complainant so and so was also examined and recorded. This is the complainant, which is that has been recorded. His statement under section 161 CRPC in connection with the instant case. His residence is located and so. He stated that in the year 2011, he was designated as DIG headquarters and he was looking after all pension-related cases, and as such, during the year 2011, 23 service books along with 3 service books in addition was returned to him from the office of the Accountant General Kohima, stating that the service book was suspiciously fictitious. Accordingly, he also carried out inquiry and found out that such pension cases were never forwarded from the concerned units. In this regard, he lodged a complaint at SCPS PHQ Nagaland Kohima. His statement corroborated with that of the FIR, investigation also revealed that no entries were made in the receipt register and was not marked by DIG BHQ headquarters. However, investigation has revealed that the pension cases were found to have directly reached pension branch without the knowledge of DIG headquarters, Lordship. This is the statement recorded under section 161 CRPC, Lordship, of the complaint. 16.11. In the course of investigation at PHQ, Sri so and so was also examined, wherein he stated that he was a commandant of 3rd Lieutenant Tengsang in the year 2011. On showing the question documents which bore the seal and signature of 3rd NAP Tengsang, he stated that the signature, very important, Lordship, he stated that the signature does not belong to him and that it may possibly be forged, Lordship. His statement corroborated with that of the finding from the 3rd NAP Battalion Tengsang, Lordship. This is the statement of Commandant 3rd NAP, Lordship. Now, Lordship, coming to 16.2, Pension Branch PHQ Kohima. Further investigation revealed that all pension cases were forwarded directly to Pension Branch without the knowledge of DIG headquarters for scrutiny. No entries were also found in receipt register, which corroborated with that of the finding from the purported claimed unit as found in the question documents. Accordingly, 16.3, accordingly, Assistant Office Superintendent AOS Pension Branch Sri so and so was also examined and his statement recorded, whereas his statement corroborated with that of the finding in regard to the process of pension cases. He further stated that after the pension is received from DIG headquarters, the pension cases are then scrutinized from the branch, and after obtaining all necessary forwarding, the pension cases are then forwarded to AG Office Kohima for further course of action. Now, important, Lordship, on being asked about the staff who were responsible to look into the pension cases, he stated that Srimati Imtikam Lao, retired, was the AOS. Now the respondent, Sri Jongsong Pao, was the nodal officer. Very important, Lordship, was a nodal officer. And Srimati so and so, retired, was a record keeper who was responsible for all the record keeping in regard to the pension cases, Lordship.
Yeah.
So now, Johnson Pao, the present respondent who was alleged main accused, was found to be promoted from UDA to AOS and transferred to technical branch PHQ Kohima, Lordship. Now the
Just a minute. Who was the main accused? Yes.
the main accused is
Needs to be main accused.
the respondent, which his statement has been recorded.
Yeah.
16.23. Lordship.
Yes. All right.
But I would also like to,
Jong Awa.
Lordship,
Jong Awa.
but I would also like to read the statement of the
Okay. Statement of the.
statement of the other accused, Lordship.
Yes.
Lord.
Yes. After
After
lunch.
no, after.
Sure.
Itu hilas arah arah dulu.
무슨 누구 나의
Nah,
내가
kata bapak itu kata.
숏컷 말이 되기도 너보래. 그냥 내셔야
Itu awal.
If person is used more than one something, those organizations are commenting to Gitu ya. 10 tuh. Itu we print out করবে। হয় হয় আপনারা প্রত্যেক না সেটা আমি gitu. Now you remember না?
For delivery of judgment, item number 2.
In the factual matrix of the instant case and in the backdrop of the above discussion, initiation of a proceeding under the DV Act against petitioner number 4, Sharma Praveen, sister-in-law of the aggrieved person, is set aside and quashed. However, with regard to the other petitioners, being the husband, father-in-law, and mother-in-law, the court does not find sufficient merit for quashing within the ambit of the law pertaining to squashing under the DV Act. To that extent, their prayers are rejected. The stay granting, halting further proceedings stands vacant. The criminal petition is allowed with regard to petitioner number 4 and dismissed with regard to petitioner number 1 to enter disposed of.
For bail hearing, item number 1, bail application 906 of 2026, Principal C.
I'll quickly hearing, then we'll proceed.
But in this case, my lord, I was arrested on 14/5/25. Today I have completed 397 days, man.
I see.
And my lord, 3 witnesses have been examined. She has refused the medical examination. And my lord, further information was also given opportunity by your lordship. That was also done.
Okay.
May I please proceed?
Yes.
Here in this case, this is a POCSO matter. Notice was sent to the informant, and as per my instruction, notice was served.
Yes.
So, Lordship, as there is no counsel from the informant side, so Lordship, amicus may be appointed, Lordship.
Is it?
You were appointed earlier, man.
Amicus, no.
Mr. S.C. Biswas, appearing from Gauhati, principal seat, through the online mode, and also the learned additional PP for the state. Full stop. The learned additional PP submits that service upon respond number 2/informant has been completed. Full stop. However, none has appeared on behalf of the informant. Therefore, okay. M.K. Brown, Miss M.K. Brown, learned counsel, is hereby appointed as amicus to represent the respond number 2. She may be given a copy. We can take it up tomorrow also if you agree. But tomorrow, bench is there, and I think several matters have been fixed. So I don't know when we'll rise. So should we fix it day after tomorrow?
Lordship, here in this one more thing, Lordship.
Scan TQ is available, you right?
Scan copy execution. Then Lordship, day
After yeah. One more thing.
tomorrow, Lordship.
Day after tomorrow.
Thursday. Tomorrow we can do those.
Tomorrow, you may. I do not want to keep you.
Day after tomorrow.
We have a division bench and several matters have been fixed. So I do not know. We will get date in rising. So
Day after tomorrow.
better it will be fixed on Thursday.
Lordship.
Thursday. Okay. Should we fix it at 2 o'clock on Thursday? 2 o'clock. 2 o'clock. Thursday 2 p.m. 18.
Who is the amicus curiae? Copy.
Miss Manisha Brown.
MK Brown.
MK Brown.
I'm giving you the copy today itself, man.
Yes.
Diploma.
Okay. Day after tomorrow we'll take up at 2 p.m. Okay. Take this.
I'm deeply obliged, man.
Yeah. Right. Yes. Thank you. So we'll restart the narration.
Lordship,
Somewhere.
page 61, charge
61.
page 61.
Yeah.
16.4.
Mhm.
16.13, Lordship, this is a statement, this was examined. One assistant office superintendent. And from the statement here, he also revealed that the present respondent was a nodal officer. Now coming to 16.4 Lordship, this is a sequence of procedure for pension received at PHQ to PHQ to till settlement, Lordship. Lordship, first, the pension paper has to be processed from the respective unit. Thereafter to PHQ,
DIG headquarter.
DIG headquarter, Lordship, and to pension branch, to accounts branch, leave encashment, or GPF to pension branch. And after that, again, it is from the pension branch, it is scrutinized, and thereafter it is sent back to DIG headquarter. And after that, it is sent to AG, Nagaland Lordship. And thereafter, from the AG, once it is done, it is sent back to PHQ for confirmation. And at last, AG for settlement of pension project. This is a procedure, Lordship. This is a sequence, Lordship. Now, Lordship, coming to 16.5, Lordship. This is one of the accused who are also involved, Lordship, is in 16.5, Lordship. I may continue, Lordship. In the course of investigation, it has transpired that Ms. So-and-so, computer assistant, is also suspected to be involved in the above case. She was examined from the pension branch PHQ, so-and-so. So-and-so, on being examined, she stated that she joined service in the year 2007 and has been posted to the pension branch PHQ as computer operator till date. She further stated that in the year 2011, DIG headquarters was so-and-so, and the branch IO was so-and-so, and now Johnson Po, the respondent was the dealing assistant. She further added that her assignment was to type all the necessary forwarding to sign to DAG headquarters and then send it to AG office for by the nodal officer. And at that point, relevant point of time, the nodal officer was the respondent. On being questioned about the working system of the pension processing, she stated that after the pension cases were received from various units from the DIG headquarters by DIG headquarters, and after making necessary entries in the receipt register, Lordship. Lordship, I will skip to that, and Lordship, make 16.6, Lordship. After all the completion of procedure from PHQ, the nodal officer will take all the pension documents to AG office personally. She further stated that our Johnson Paul was appointed as nodal officer who will be responsible to take all the pension documents to AG office personally. On being questioned about the entries made in the note sheet, she revealed that during the time the respondent called her up and asked her to scrutinize the pension cases and make all necessary entries in the note sheet. She reluctantly agreed and processed it only as per his direction, Lordship. This is a statement of one of the suspected involved, Lordship. She is the computer assistant, Lordship. And she have also mentioned that at that relevant point of time, the present respondent who was the nodal officer, and then she even made her statement saying that she reluctantly agreed and processed it because of his direction, Lordship. And Lordship, coming to coming to 16.9, Lordship. 16.9, Lordship. Srimati so-and-so was examined wherein she stated that she joined the service in the year 1986 as record keeper and retired on January 2021 from the receipt and dispatch branch. She further stated that on 2011 she was posted at pension branch PHQ as record keeper, where DIG headquarters was so-and-so, and that her assignment was maintained to the list of all the pension voluntaries, medical and full pension, Lordship. Lordship, I will only read the relevant paragraph, Lordship. The relevant paragraphs are from the dealing assistant, Lordship, if Lordship has got it. The dealing assistant.
Yes.
The dealing assistant so-and-so will then sign, Lordship. Here, even the statement of
On the respective charge,
lordship,
then so and so.
respective
DF
DF and so and so. During the year 2011 and 12, the respondent was looking after battalion pensions and DF pensions were looked after AOS so and so. She also stated that the dealing assistant or AOS usually make all necessary increase after scrutinizing all the pension documents where these are further scrutinized by AOS and the dealing assistant lordship. Now, lordship may come to 16.220. Srimati so and so, on being examined, she stated she is working as pension branch PHQ as AOS till 2014, Lordship. Lordship, I will only read the relevant paragraph 1621, Lordship. She further states that after the record keeper compiles the entire pension into the DF and battalions, they scrutinize all the pension documents along with the service books, and after completion of all the necessary examination, it is then forwarded to OS, who then forwarded to DIG headquarters for further necessary action. After completion of all the necessary formalities, all the pension papers along with the service book are then forwarded to AG. On being questioned about the file allotment register, very important, she stated that either herself or the dealing assistant, the present respondent, make all necessary entries after scrutinizing all the pension documents. With regard to the present case, she stated that the disputed pension papers are not deliberately processed by her as alleged. Whatever she received from the present respondent, she forwarded to the authority for further course of action as deemed fit. Now, the statement of the present respondent.
He is the prime accused or what?
He is the prime accused. From the statement of statement recorded from the AOS as well as computer assistant, all those lordship. It involves to the present respondent lordship.
He is the respondent.
Lordship.
He is the respondent.
And
so, yeah, we should, of course, overall picture is necessary,
lordship.
but we should also focus on the materials pertaining to him,
Lordship.
since he's the only respondent here.
Lordship. Lordship may kindly come to 16.34, Lordship.
The discharge order had discharged several persons or only one?
Only one person.
Others? How many were sent up for trial, the investigation?
Two.
Only two.
Yes, both the accused persons filed separate discharge petitions.
Okay, this
Now both those
Mr.
petitions
Awa
and one lady.
That's background.
The name,
That
her
computer
name,
assistant.
if my lord will kindly go to page 65.
65.
Yes. In paragraph 16.29, the other accused names are listed. Here, this serial number 3, she was not charge sheeted.
Let me answer. These are
The names of the accused.
names of the accused. Three were
Yes.
sent up for trial.
No, only two.
Two.
Yes, no charges were framed against this serial number 3. Now, this serial number 1, who is the present respondent, as well as this serial number 2, they filed separate discharge petitions before the trial court. Both were allowed. Now, the state is not aggrieved by the discharge of the other co-accused persons, whereas they have preferred in
Imti Kumla Ao, the state has not filed.
state has not.
But
filed.
again,
Yes,
Mr.
yes,
Abba, the
yes.
state has.
Yes, yes. The
I'll not go
Against
into
the main
that
respondent.
we'll focus on more on the materials regarding.
My lord.
Lordship. Lordship may kindly come to 16.34, that is on page 66, Lordship. This is the report, Lordship.
Okay.
CFSL report.
16 point, I am on page 66. Yeah.
Lordship.
Proceed.
16.34. Lordship. CFSL report received in the process, the question documents as well as voluntary writing and signatures of all of alleged accused persons were forwarded to the Central Forensic Science Laboratory, Kamruk, Rural, Assam for examination and value opinion for the purpose of evidence in the learned court of law. The expert report dated 31/5/2022 had opined that 1. The person who wrote the blue enclosed standard writing and signature stamp and marked S1 to S20, A1 reproduced copy and A2 reproduced copy also wrote the red enclosed question writings and signatures similarly stamped and marked Q1 to Q6. 2. The person who wrote the blue enclosed standard writing and signature stamp and marked serial number S21 to S40, A6 and A7 also wrote the red enclosed question writing and signatures similarly stamped and marked Q7 to Q9, Q11 and Q12. 3. The person who wrote the blue enclosed standard writing and signature stamp and marked S41 to S60, A3 to A5 also wrote the red enclosed question writings and signatures similarly stamped and marked Q13 to Q18. Prosecution sanction received. In course of the investigation, requisition for according prosecution sanction under section so and so CRPC under section so and so in respect of the present respondent and Srimati so and so, which was paid to the director and also received from the Home Commissioner Nagaland. Omission of section 468 and 469 was omitted, Lordship.
Okay.
And recommendation, Lordship. Lordship, if recommendation 16.37. From the above cited facts and circumstances, it is evident that the alleged man accused, Johnson Powell, so and so, had deliberately scrutinized the pension cases from his own personal reason. He further directed the computer operator, so and so, to scrutinize the pension cases which were kept under his table and do the necessary forwarding from her end, who reluctantly agreed despite knowing fully well that she was not authorized to do so, Lordship. Now, Lordship, coming to the CID report, which is at page 91, Lordship. CID report in the State Crime Police Station, case number so and so, Lordship. Lordship. Now I will only read the relevant portion, which is at page 114. 114. In view. Conclusion.
Mr.
114. This is the conclusion, Lordship. Lordship, I would also like to rely the CFSL opinion, Lordship. 113. 113. Para 1111. CFSL opinion. During the course of investigation, CFSL opinion was sought to prove whether the signatures and writtens in the alleged pension documents processed by A1, A2, and so belong to them. This GEQD opinion dated 31/5/2022 has confirmed the signatures and written on the alleged documents, Lordship. It has been confirmed, Lordship. And Lordship may kindly come to page 114. This is the conclusion, Lordship. In view of the above discussion, it is clear that 26 fraudulent pension papers have originated in the pension branch PHQ and that the accused 1 and accused 2, having the knowledge of the same, have connived with each other and fraudulently processed the pension papers, obtained the approval of the competent authority, and forwarded and submitted the alleged fraudulent pension paper to the AG office. However, no loss has been caused to the government as the same was detected before the pension paper were approved by the AG. Thus, from the above cited facts and circumstances, it is evident that the alleged accused, so and so, and A2, so and so, had committed offense punishable under section 120B, read with 409/511, read with 420/471 IPC, and they have conspired with each other and been public servant and committed criminal breach of trust by fraudulently processing the false pension paper. Further, they having had the knowledge that the pension documents not forwarded from the concerned units and that they were false, forged, and fabricated, have scrutinized and processed them as genuine documents and have attempted to cheat the department, Lordship. Now, Lordship, they are all together two accused, and moreover, Lordship, coming to page 117, Lordship.
But prosecution is not filed, as you said, against.
Lordship.
Only the discharge of A1 has been challenged.
No, Lordship.
Page.
Page 117, Lordship. This is the calendar of oral evidence, Lordship. They are all together PW 39, Lordship. 39.
39.
Still 122. And now, for defense, D12, starting from 123, page 123 to 121, D23, Lordship.
One 23. 117 I marked.
Lordship. Starting from 117, Lordship, page 122 is altogether PW 139.
Documentary evidence.
Lordship. And the 120, starting from 123, page 123 to 127 is D1 to the 23. Lordship, we have categorically stated in our revision memo, Lordship, starting from page 23, Lordship, of the petition, Lordship. Since all the statement has been recorded, Lordship, I will only read ours. Page 23, Lordship. If paragraph 22, Lordship.
Page
23, paragraph 20.
Yeah.
Paragraph, if I'm not correct. Paragraph 20, that it is respectfully submitted that a learned CJM Kohima had failed to appreciate the fact and circumstances of the case in deciding the discharge petition, as the facts clearly pointed out that a pension paper were prepared from the PHQ and forwarded to AG Office Kohima by the accused respondent himself. It is clearly stated in the charge sheet, para 1623, and admitted by the accused himself that there were many pension cases in the year 2011 and 2012. At that point of time, two unidentified, very important, two unidentified persons came to his branch and approached him with a request to process the pension files and handed him cash, which he accepted. Though he didn't exactly remember who they were and how they got it, and that he did not remember the name of the personnel for whom he had processed. The respondent did not make any interest in the receipt pension register, but he processed and put it up for further forwarding. He admitted that usually any pension cases received from the units will be entered in the receipt pension register. But in this case, he did not remember making any entry in the receipt register. The action of the respondent clearly shows that the respondent had accepted some cash from strangers to process the file, which amount to bribe, as government officials. Accepting cash to perform his duties is a criminal offense. Also, it is not safe to accept cash from the stranger from doing any kind of work, but the respondent and taking cash to perform certain acts and violated standard protocol of the department in processing the pension paper. However, the premature discharge of the respondent from the liability had prevented the prosecution for establishing the guilt of the respondent beyond reasonable doubt, despite hard evidence available to prove his guilt, Lordship. Lordship, para 23, that it is humbly submitted that the learned CJM Kohima had also failed to take into account the action of the respondent who directed his subordinate colleague, particularly PW18, as I read out, Lordship, PW18 computer assistant from doing unauthorized work, such as the scrutinize their pension cases and make all necessary entries in the note sheet, which she is not authorized to do, but was forced to do by the accused respondent. Such acts of respondent is suspicious at the outset and questionable as to why he had to ask the PW18 to make such entry, as he being the nodal officer is authorized to scrutinize and make entries in the note sheet. Nothing less, the learned CGM Kohima erred in law and facts in discharging the respondent before trial could take place to establish the guilt of the accused respondent. That it is 24, that it is humbly submitted that when the respondent himself was the one to take the files to AG office after scrutiny and clearance from the DIG headquarters, it is futile to take claim of not having any means to ascertain whether the signature documents were authenticate or forged, as it is his official duty to scrutinize the pension papers sent to PHQ from different units, battalion, or whether the respondent had seek any query clearance from the respective claim unit before anomalies were detected by AG Kohima, or whether he had approached his superior authority by reporting that he had received the file from unidentified persons. The charge sheet shows that the respondent had not seek any prior queries from concerned unit, battalion, nor approached the PHQ, nor he had aware of the false pension claim before it was detected, Lordship. Lordship, as it's clearly mentioned in the charge, Lordship, page 61, Lordship, 16.14, where there is a sequence of a procedure for pension, Lordship.
16 point, page?
Page 61, Lordship. 16.14, Lordship. So this process was not done, Lordship. Page 61, Lordship.
16.14.
16.14.
Yes, I've seen this.
Process for respective unit, Lordship. The unit has never processed the pension paper, nor it was sent into the DIG headquarters, or nor it was been scrutinized by DIG, and it was directly forwarded to the AG, Lordship. If I may continue, Lordship, page 25, Lordship. That the pension cases reached the pension branch without the knowledge of DIG itself raised the credibility and integrity of the accused himself, as it was his duty to submit the file before the OS, office superintendent, and then forwards it to DIG headquarters for further necessary action. The omission on the part of the accused respondent is not following complying the laid down procedure is itself a serious offense and attracts departmental disciplinary proceeding, whereas in the instant case, the learned CGM Kohima had overlooked all the relevant facts in discharging the respondent by denying fair trial to the prosecution. It is further submitted that the instant case is not a case of having expert knowledge to ascertain whether documents are forged or not by whether the proper procedure is complied or not in forwarding the pension paper from PHQ Kohima to AG Office Kohima, where non-compliance of the laid down rules had resulted in detection of the false pension claim by the AG Office Kohima, Lordship. And Lordship, I have relied on two Supreme Court rulings, Lordship, which is at page 28, Lordship.
Wait.
Page 28, Lordship, if I'm allowed to read, Lordship. Page 28.
No. Page 28, para 28 also, huh?
Lordship, para 28. That the petitioner placed reliance on the case MS Supreme Court so and so for accused person licensing department of the company whose job was to identify the farmer whose lands were taken over by the project of the company and get the payment by check released to them by way of compensation for the land prepared by check in some other person's name, thereby misappropriating the money. They were charged under so and so, under section so and so, and of IPC and granted bail anticipatory bail by the High Court. But on appeal, the Supreme Court held that the offense being serious in nature of fraud, cheating, and misappropriation, the bail needed to be cancelled. The role of the accused person in duping the innocent farmers of their money cannot be ignored. Similarly, in the instant case also, Lordship, the innocent police retired personnel have no idea that false pension claims has been made in their names, and which is further corroborated by the statement made before the investigating officer. However, unfortunately, the learned CJM had tended to ignore these crucial facts by ultimately discharging the accused who had knowledge and made use of the first documents for his own benefit. As such, the petitioner can only pray to this honorable court for intervention and set aside the order dated 3/10/2024, Lordship. Lordship may kindly come to the statement of the accused, Lordship, which is at page 84, Lordship.
Page 84.
Page 84. Now, page 83. Pardon me.
83.
Page 83.
Yes.
If I may log the read, Lordship. Statement of accused number 1, Sri so-and-so, the present respondent. On being interrogated, he stated that the above given information were true. And to the best of his knowledge, he also stated that he was working as pension branch PHQ from 2002 as UDA till 2012. In CW, the above instant case, he was suspended for a period of 6 months and got reinstated again, after which he got promotion in the year 2015 as AOS and thereafter got promoted as AOS and is currently a technical branch PHQ. On being interrogated, he stated that in the year 2011, I was posted at pension branch PHQ as UDA. During the time, DIG headquarters was so-and-so, Sir so-and-so. I was the branch dealing assistant and I look after the pension related matter along with our AOS, Sir Mati so-and-so, who is retired as now. On being questioned about the working system in the branch, he stated that the pension paper along with the service books were forwarded from various units to PHQ, whereas in the present case, it was not forwarded, whereby DIG headquarters will receive all the pension-related matters and after making all necessary entries in the receipt register, the documents along with the service book will be forwarded to pension branch. After that, the record keeper will make all necessary entries, and after that, DEF and battalion pensions are compiled separately. On being questioned about who looks after the pension matters, he stated that I look after all the battalion's pension matters and AOS so-and-so look after the DEF pension matters. He further stated that after the record keeper compiles the entire pension into DF and battalion, we then scrutinize all the pension documents along with the service books, and after completing all the necessary examination, we then compile all the pension matters and forward it to the OS superintendent, who then forward it to the DIG for further necessary action. After completion of all the necessary formalities, all the pension paper along with the service books are then forwarded to AG Kohima. On being further questioned about the nodal officer who dispatches all the pension documents to AG office, he stated that during the year 2011 and 12, I was appointed, very important, I was appointed as nodal officer and that I used to submit all the pension cases from PHQ to AG office. When questioned about the file allotment register, he stated that usually myself or the heirs all the necessary entries after scrutinizing all the pension papers in the file allotment register. On being further questioned about the register of submission of pension cases to AG Nagaland, he stated that it was since he was appointed as a nodal officer, he usually make all the entries while submitting it to AG Office Nagaland. However, upon confronting him with the latest finding in CW, the above case and how the investigation was finally narrowed down to him, he finally stated that during the year 2011 to 2012, he was appointed as nodal officer and that I was responsible to submit all the pension cases from PHQ to AG office. He further added that there was many cases in the year 2011 where at some point 2 persons came to our branch and approached me that then it was
Then some page is missing on.
Page, some page is missing, but however, Lordship, this.
It will be in the, can I find it in the record for my later reference? Hopefully, hopefully. Yeah, I think one page is missing. Anyway, so next week.
Lordship,
yeah,
that
yes,
page will be continued from page
Just a minute. You see,
85.
Page 34 is mentioned, right?
Lordship.
34. After that, the next statement is 36. That means 35 pages missing.
86, my lord.
Should be there.
The next page is at page 86, my lord.
86 will be the.
Oh,
Yes, there has been some
There's been some.
No, then it's not.
mistake with the page arrangement, my
That's
lord.
not a problem.
Yes. Page
Oh,
86.
doesn't matter. That's okay. Nodal officer. Officially. He was the nodal officer, right?
He was the nodal officer, Lordship. Remember clearly that some long, don't 86 is the continuation, Lordship.
Yes,
I don't remember clearly as to it was some long years back. It was nodal officer. No, Lordship. Continuation of 83 will be 85.
5.
No, that's
They then enter, yes. Right. They then requested me to process the pension.
Yes, Lordship.
I
Then
call-
requested me to
I
process, Lordship, 85. Requested me to process the pension file. I don't
don't
remember exactly remember who then, where, and how they got it, but they came and approached me. They handed me some cash. Very important, Lordship. They handed me some cash in an envelope and requested me to process it earlier. It is accepted and then process the pension from my end, though I don't remember the names of the personnel whom I have processed. On being questioned about whether the names were included in the receipt pension register, he stated that I do not make any interest in the receipt pension register, but I process it and put it up for further forwarding. He further added that any pension cases received from the unit will be entered in the receipt pension register. But in this case, I don't remember making any interest in that receipt register. On being questioned about if any point whether he had asked or directed anyone to verify any of the question documents, I don't remember the date of time, but when I was out of station or whenever I was not well, I will call up our computer assistant, Mrs. So-and-so, to take out the pension case file from my table and verify it. This corroborated with that of the statement of the computer operator, who stated that she had verified the pension cases as per direction from the so-and-so respondent. They further stated that only the person who had scrutinized and verified the pension files, they will put necessary remarks in the note sheet of the personnel file of the personnel against whom pension was processed. The handwriting and the signature which was found in the note sheet of the question documents is mine, and that I have given the remark after scrutinizing the pension documents. That the above statement given by the alleged accused fully corroborated with that of the finding in the course of investigation. Though the alleged accused admitted that it was nearly 10 years ago that the case happened, he could not recollect who those persons were, Lordship. Lordship, in fact, some unknown person has approached him, Lordship, and even offered him a case, Lordship. So, Lordship, to that, Lordship, we have categorically stated in paragraph 27, Lordship. So, Lordship, there is a prima facie case against the said respondent, Lordship. Lordship, and then Lordship,
what are the reasons given by the, because as you know, when you frame a charge, you don't have to write a detailed order. You know, there are judgments, we know them, of the Supreme Court. So too much of a detailed order or in a charge framing order could prejudice also the defense. But anyway, so you can frame charge. So, however, discharge is like acquittal without trial. So for discharge order, more detailed reasons have to be given why it has been, why the person has been discharged. That is also case law. So what are the reasons given by the learned CJN for discharge?
Lordship.
Can we just you complete yours, then we'll go to that, or maybe we'll go to that when you before you.
Yes, my lord, my lord, my lord.
You complete it, sir.
The reasons for that, my lord, basically, that the ingredients, my lord.
Basically, we have to, that is, we have to
Yes.
see the
400 line.
see the materials. Whether
Yes,
they
my
are
lord.
specific.
Yes, my lord. That the ingredients were not satisfied.
Yes. Yes.
Lordship, I will also in support of my submission, Lordship, I will rely on three judgment, Lordship. The first one is 2001, one SSC is 719. This is Shibai, Livabai, Changani, Lordship. Lordship, had no conviction and sentence on the appellant using a duplicate certificate or mark sheet which changes as true certificate, knowing it to be false in material particulars and thereby getting admission to polytechnic course, held conviction justified. However, looking to the nature of the offense and the fact that the appellant past and present records have been good and the fact that he has already lost his career and is now married, his sentence was reduced also. Lordship, the second reliance is 2023-17 SSC 688, Lordship. And the relevant paragraph starts from operating paragraph starts from
Para.
para 12, para 12, 17, 18, and 19, Lordship.
Yes.
And Lordship, the third and the line is on 2021, 8 Supreme Court cases, 758, Lordship. And the paragraph and the paragraph I'm relying is on paragraph 26 and 27. So, Lordship, our case is that, Lordship, there is a prima facie against the said respondent, Lordship. And Lordship, if Lordship has right to point it out, Lordship, if Lordship may kindly come to the discharge order, Lordship, which is at page 158.
Yes.
128
The order,
of the order, Lord.
page
128.
128.
128.
The discharge order, I believe it is at page 34. 128 is the discharge order of the co-accused.
Oh, yeah, 34 is the charter. Yes. 34.
34, ma'am.
334? Long order has been written. Has to be this. Reasons have to be given, long or short, whatever.
On page 34,
You can show me the relevant parts also.
Lordship. The relevant paragraph start from paragraph 6, Lordship. Page 36, Lordship.
There are 6.
Starting from paragraph 6 to para 6 to para 33.
Para
Para 6 to para 33, Lordship.
32.
33.
I think almost a whole thing. There are 6 onwards. I'll make.
Para 6 onward. So, Lordship, from the charge sheet and from the statement recorded of the accused number 1, accused number 2, and all those statements which has been recorded, Lordship, everyone has been pointed to the respondent, Lordship. Since at that relevant point of time, the respondent was the nodal officer, Lordship, and he was the one who has been processing all the pension paper, Lordship. And in fact, from the findings of the SIT, Lordship, it clearly appears that from the SIT, Lordship, it clearly appears from all the battalions where it is found that no pension paper has been processed from all the unit, Lordship. And Lordship, as I clearly stated that once the pension paper has been received from the respective unit, Lordship, first it has to send it to the PHQ, DIG headquarters, Lordship. And thereafter, after the scrutiny, it is sent back to the pension branch again for scrutiny, and after that it has to send it to the DIG PHQ, Lordship. And thereafter, once this scrutiny is done, it will send it to the AG office, Lordship. But that was not done in the present case, Lordship. That is my case.
The learned court below believe that, okay, the materials are not sufficient.
Lordship.
The investigation was done by SIT.
Investigation was done by SIT, Lordship. One.
Right. That's all from your side?
That's one.
Wait.
Lordship, here is a case where the accused has been discharged, or in common parlance, we may say he has been acquitted, my lord. Now, before I begin, Lordship, I would like to take my Lord, to the decision passed by the Honorable Supreme Court in State of Rajasthan versus Shiraram in 2012, 1 SCC 602, Lordship, paragraph 14. That there is a huge difference, Lordship, between a judgment, a challenge to a judgment against conviction, and a judgment to a conviction.
I'll have to see from the book.
Yes, my lord.
Give me the citation.
2012, 1 SCC 602, my lord. Paragraph 14.
See, 2012, 1 SCC
602.
602. Name of the case?
State of Rajasthan versus Shiraram, paragraph 14, Lordship.
Paragraph 14. State of Rajasthan versus. I'll find out. Shriram. Cheraram.
Yes, my lord. Shiraram. Shiraram.
Okay. We go to para 14.
My lord. It's a short paragraph. A judgment of acquittal has the obvious consequence of
Wait,
granting
wait.
freedom to the accused.
I think para 14.
My lord. 1-4.
It's not matching. The having deliberated upon the above question of law. You cross-check once. SEC citation, sometimes they change the para number.
Lordship, in page 489, top of the page, Lordship.
There is a very thin start like that.
Adequate.
How does it start? Sentence. Original para, sometimes they change.
Yes, my lord, my
Supposed
lord.
to.
My
But
lord.
they change.
Lordship.
Original para, nobody is supposed to. The judgment belongs to the court. The
Lordship.
journals, head notes is theirs, but the judgment belongs to the court.
Lordship, I'll furnish the.
But I can follow from you.
My lord,
We are
my
on the same judgment, so I can follow. You just tell me how it starts, the line. Probably it is not para 14, it's something.
It's para 7, my lord.
Para 7.
Yes, my lord.
A judgment of obvious consequence.
Yes, my lord.
Judgment of obvious consequence. No?
A judgment of acquittal has the
is
obvious consequence. Yes, my
It's
lord.
para 4.
Para 7, Lordship.
Para
I'm sorry.
Para 7.
A judgment of acquittal has the obvious consequence of granting freedom to the accused. This court has taken a consistent view that unless the judgment is in appeal is contrary to evidence, probably erroneous, or a view which could not have been taken by the court of competent jurisdiction, keeping in view the settled canons of criminal jurisprudence, this court shall be reluctant to interfere with such.
The standard of reversal is very high.
Lordship.
This we are on a slightly different footing.
Yes, my lord, my
Though
lord, my lord.
some broad principles might be common.
Yes, my lord.
Judgment of acquittal, the presumption of innocence gets reinforced.
Lordship.
So it has if it is perverse or something
My lord, my
completely
lord,
wrong,
my lord.
then it can be.
Yes, my
Usually
lord.
that's not into
Yes, my lord. Here again, Lordship.
Here, the question is, again, I said, the reasoning given by the materials found against the A1,
Lordship.
the respondent, and why it was not considered sufficient. So we have to just focus on
Yes, my lord, my lord. Now, Lordship, here the state has approached this honorable court by way of a revision petition, not an appeal, Lordship. In revision, the scope for interference is lesser, my lord.
Yes.
Unless
The charges
there is
challenged
previous
in
illegality,
revision.
Lordship.
The charge is challenged in revision only.
My
Hearing
lord.
of charge or discharge,
My lord.
challenge in revision only.
Yes, my lord. But
So
despite that, Lordship.
within the parameters of discharge,
Yes, my lord.
revisional jurisdiction, we have to see.
Yes, my lord, my lord, my lord. That is also my point, that within the parameters of revisional jurisdiction, Lordship, the present petition may be considered. That unless there is previous illegality, Lordship, or it is patently illegal, just because a different view can also be adopted, Lordship,
So
it may not be interfered. Now, my lord, if I may be permitted to take my lord to Annexure 2 at page 48. even if, my lord, if this instead petition is treated as a petition under
Keep this.
petition praying for the exercise of inherent powers of this honorable court for quashing of the criminal proceedings, lordship, even then, lordship, I have a good case on so many aspects, lordship. Here, in page 48, annexure 2, lordship, this is the written FIR is not there, of course, lordship, but here, when the FIR was filed, when it was registered, is clearly reflected, lordship.
Yeah.
In column 3, lordship,
Yes.
APC, information received that 31/7/12. That is 31st of July 2012, lordship. Now, at the top of the page, lordship, the FIR was registered only on 17th of August 2012, lordship.
Okay.
There is a delay, lordship, of about 17-18 days.
In registering.
Yes, lordship. In registering the FIR, lordship. That has not been explained, lordship.
That would not be considered a delay in FIR, but that will be considered a different kind of delay.
Yes, lordship.
Some kind of an administrative delay. Right. So anyway, it's better.
But lordship,
They might have conducted some inquiry, but it's better if an explanation is forthcoming.
yes, my lord.
That's your
Lordship.
correct in that.
Yes, lordship. That, lordship, the delay itself may not be fatal, but when there is no explanation of the delay, lordship, then it may be fatal
No,
to the prosecution's
no.
case.
The delay from the point of view of the informant, the incident has taken place today. I, as an informant, file it after 2 months.
Lordship.
That I have to explain. That
Yes.
might be very, that might raise questions.
Lordship.
But suppose I file my FIR, suppose,
Lordship.
and the police registers it after a week.
Yes,
It's
lordship.
not really, here it's a different matter that the informant himself is a high police officer.
Yes, lordship.
So that principle strictly would not come. But as a private person, once I have filed a complaint, if the police registers after a while, that's not in my hands. Never.
Lordship, but why it was
But,
registered only after
but
17 to
there may
18
be a
days?
Administrative delay.
Yes,
which
lord.
might
But
explain, which may have to be explained at the
yes, my lord. My lord.
prosecution.
Yes.
As an informant, I do not have to explain.
Yes,
I
my
am
lord.
informed.
Yes, my lord. Now,
If
once
I delay in informing vis-a-vis date of incident,
yes, lord.
then it's something that I have to explain.
Exactly, my lord. Now,
Right?
my lord, after this, lordship, charge sheet has been filed. In the charge sheet, there is no explanation why the case was registered only on 17th of August 2012 when the FIR was filed on 31st of July 2012. No explanation at all, lordship.
Okay. Then- Next point.
Now, lordship, the Home Department is one of the largest department in the state of Nagaland.
Everywhere.
Yes, lordship. Now, the pension papers are being submitted on a daily basis, lordship. Bulks and bulks of pension papers are being submitted, lordship. Now, it is, lordship, as a subordinate officer, lordship, it is our duty to receive it and, lordship, forward it to the higher authority, which
So-
has
so
been
you're
done
trying-
in.
You're contending that it may not have been deliberate.
Yes, my lord, that is what, lordship. Which is why, lordship, the prosecution has dropped 468 and 469 against me. 471 and 468 and 69 are totally different, lordship. 468 deals with forgery. They are not pressing the charge of forgery. That I created those documents, I manufactured those documents, lordship, and I have, my lord, forged the handwriting or the typewritten documents, whatever it is, lordship. Those charges have been dropped. Now the allegation is that, lordship, I have used a forged document as a genuine document, lordship. That is the allegation against me. Now, how am I supposed, Lordship, to know that each and every piece of paper that comes to me, Lordship, we generally assume, Lordship, that the signatures are genuine, that the papers are genuine, Lordship. Now, Lordship, if I may be permitted to take my Lord to the last page of the charge sheet, Lordship. Page 68, Lordship. In order to save time, Lordship, I would like to limit my submissions, Lordship.
Now you say whatever you have to say, want to say. Yeah. I'm on page 68.
Yes, 68. The charges against me are 409, 420, 471, 120P.
Right.
Lordship, here, Lordship, there is no entrustment of property, Lordship. In the entire prosecution's case. Nor has property been delivered, Lordship.
Okay.
Because that question is important for deciding 420, Lordship, as well as 409. If I may be permitted to take my... For that, Lordship, I would like to place reliance on the decision passed by the Honorable Supreme Court in 2021, 18 SCC 70, Lordship. 2021, 18 SCC page 70, Lordship.
It's a different one.
Yes, Lordship.
Okay, tell me 2018.
2021.
21.
Yes, 18 SCC.
Page
70.
70. Name?
N.
Raghavendra.
Raghavendra, Lordship, versus State of Andhra Pradesh.
Let me write it down. Para?
46, Lordship. My Lord will find it at page 94. Here are the essential ingredients, Lordship.
Yes.
409 have been discussed, Lordship. In paragraphs 46 and 48, Lordship, I may be permitted to take my Lord to paragraph 46 first. The entrustment of public property and dishonest misappropriation or use thereof in the manner illustrated under sections 405 are sine qua non for making an offense punishable under section 409 IPC. The expression criminal breach of trust is defined under section 405, which provides inter alia that whoever being in any manner entrusted with property or with any dominion over a property dishonestly misappropriates or converts to his own use that property or dishonestly uses or disposes of that property contrary to law or in violation of any law prescribing the mode in which such trust is to be discharged or contravenes any legal contract, express or implied, shall be held to have committed criminal breach of trust. Hence, to attract section 405 IPC, the following ingredients must be satisfied. Entrusting any person with property or with any dominion over property. That person has two, Lordship. That person has dishonestly misappropriated or converted that property to his own use. 3, or that person is dishonestly using or disposing of that property or willfully suffering any other person to do in violation of any direction of law or a legal contract. Here, Lordship, there is no entrustment. There is no conversion, Lordship, or misappropriation of any property, Lordship. Now, if my Lord will kindly go to para 48, the same page. No sooner are the two fundamental ingredients of criminal breach of trust within the meaning of section 405 IPC proof. And if such criminal breach is caused by a public servant or banker, merchant, or agent, the said offense of breach of trust is punishable under section 409, for which it is essential to prove that the accused must be a public servant or a banker, merchant, or agent. She must have been entrusted in such capacity with property. She must have committed breach of trust in respect of such property, Lordship. So 409, my Lord, is aggravated form of 405.
Yes. It is.
Here, Lordship, the essential ingredient, Lordship, is that I must be entrusted first with public property, Lordship. There must be entrustment. Secondly, taking advantage of that entrustment, Lordship, I must have converted that property for my own benefit, for my own use, Lordship.
Okay. Next.
Now, Lordship, what is property? How has it been addressed, Lordship, under the criminal law, Lordship, under the IPC? In 2024, 11 SCC 733, Lordship. It's a recent decision, Lordship.
The main alleged offense against this person was, forgery. Forgery has been removed. Right?
Yes, my Lord.
Using forged documents.
Yes, Lordship.
To cause wrongful gain.
Yes,
loss,
Lordship.
And wrongful loss to the state.
Yes.
Right. That is the main.
Yes,
That is whether they are materials or not.
Yes,
Entrustment, in what sense it has been brought? Entrustment. Entrustment of what property? The pension papers.
Pension papers.
The
He was
pension.
entrusted as a.
Will that be
Loss.
property? Within the meaning of that pension papers, because it's not a pension papers. Well,
way.
how can it be misappropriated? Pension, if pension money is entrusted, then it's different.
Yes, Lordship.
But pension papers cannot be misappropriated.
Yes,
Person.
Lordship.
Anyway, let's see.
Law says that property under
focus
criminal
more on
law.
that. Huh? Focus more on that.
Yes, my Lord.
So focus more on the forgery aspect.
Yes, my Lord.
So I'll see that.
Yes, property.
Yeah, tell me that citation.
2024, my Lord, 11 SCC 733.
11 is 720.
33, Lordship.
Kindly give me one name.
Para 24, Lordship. The name is Miriam Fasihuddin versus that.
Kerala or something.
Yes, my Lord. The law is defined under the IPC. The word property means something which has exchange value, my Lord. Page para 24, my Lord, at page 740.
Yeah. Term property.
Yes, the term property employed in section 420 IPC has a well-defined connotation. Every species of valuable right or interest that is subject to ownership and has an exchangeable value is ordinarily understood as property. So, as my Lord has rightly pointed out, those documents, they do not have exchange value, my Lord. And as such, the ingredients under section 409 is not satisfied, Lordship.
My preliminary view, that's,
Yes, my Lord.
I have to see.
Yes, my Lord.
Am I right?
Now, my Lord, in the same judgment, if my Lord will kindly take the trouble of going to para 22. Here, yes, the ingredients of section 420 is discussed because, Lordship, there is a charge against me under 409, 420, yes.
20 of
Yes, charge of peace
cheating,
and dishonesty, Lordship.
paramount.
It is thus paramount that in order to attract the provisions of section 420 IPC, the prosecution has not only proved that the accused has cheated someone, but also that by doing so, he has dishonestly induced the person who is cheated to deliver property. There are thus three components of this offense. One, the deception of any person. Two, fraudulently or dishonestly inducing that person to deliver any property to any person. Three, mens rea or dishonest intention of the accused at the time of making the inducement. So, Lordship, in the entire prosecution story, in the entire prosecution case, if there was an allegation, Lordship, that property has been delivered, then 420 may be attracted, Lordship. But even at this stage, Lordship, there is no allegation, Lordship. Now, my lord, coming to 471.
471 is forgery.
Yes, my
Using
lord.
for-
Yes, using a forged document as genuine.
7 is falsification of accounts.
My lord,
That's not there. That's not.
that's not there, lordship.
Because I mix up with that more magistrate tribal, but very important.
No, lordship.
These are all financial
Yes, my lord.
crimes are always difficult.
Yes, my
More
lord.
difficult. That means property.
Yes, my lord.
Offenses pertaining to a property, which includes this kind of financial matters, are more difficult
My lord, my lord.
based on documentary evidence also. Anyway, so
Now, I would like to rely on the decision passed by the Honorable Supreme Court in 2023, 3 SCC 423, lordship. Deepak Kappa versus State of Uttar Pradesh.
2023, 3 SSC.
My lord, 423. Deepak Kappa.
Deepak Thapa.
Yes, my lord.
DEE,
DEEPAK, and then the last name is GAPA.
Gapa.
Yes, my lord. Kappa.
GAPA.
Yes, my lord.
Gap. Yes.
G for girl.
Gaba. Gaba.
Yes, my lord.
Gaba.
The catchy name.
Unfamiliar names. Okay.
Now, in paragraph 21, my lord, they speak about the ingredients, essential ingredients of section 471.
Okay. 21.
My lord will find it at page 434. 434, lordship.
434.
Yes, my lord. Para 21.
Yes.
It speaks about how section 471 is not attracted in this particular case, lordship. If I may be permitted to read it, lordship. Section 471 IPC is also not attracted. This section is applicable when a person fraudulently or dishonestly uses a genuine any document or electronic record which he knows or has reason to believe to be forged document or electronic record. This is important, lordship. In Muhammad Ibrahim has elucidated that the condition precedent of an offense under 471 IPC is forgery by making a false document or false electronic record or part thereof. Lordship, now they are saying that, lordship, a condition precedent, lordship, under section 471 is forgery by making a false document, lordship, or false electronic record. Here, lordship, there is no allegation against me for making a false document or a false electronic record. I may have been fooled, lordship. Now, lordship, again, the first sentence which I have read, lordship, if I may be permitted to read this again, lordship.
Yes.
I would like to stress on the word reason to believe. This section is applicable when a person fraudulently or dishonestly uses as genuine any document or electronic record which he knows or has reason to believe to be a forged document or electronic record, lordship. Now, my lord, Reason to believe is defined under section 26 of the Indian Penal Code. Reason to believe, Lordship, if I
A
may be
reasonable
permitted.
man will think that it exists, something like.
Yes, my lord, my lord. The word Lordship, sufficient has been used, Lordship. I believe that is the key word, Lordship. Reason to believe. A person is said to have reason to believe a thing if he has sufficient cause to believe that thing, but not otherwise. That means, Lordship, it must not be probable, it must not be possible, it must not be likely, Lordship. It must be sufficient. It must be, it is something, Lordship, more than strong suspicion. Now, when I don't have reason to believe, Lordship, if I don't have reason to believe, Lordship.
They don't, if he did not know, if he processed the papers.
Yes.
Some forced papers also. But
Yes, Lordship.
if there are materials to indicate that he had no knowledge, then it may not come.
Lordship.
But whether that truly whether someone had knowledge or not is actually a matter of evidence. But prima facie, if there are
Lordship.
materials to indicate that he had no knowledge at all, then the charge may be justified. But if there are materials to indicate that he may have knowledge, he might have had knowledge, but not sure, then it becomes a matter of evidence to be proved during the trial. So that aspect has to be seen, the degree.
Lordship.
Anyway, so.
Lordship, now, the charge sheet was filed only in the year 2024, after a delay of more than 12 years, Lordship.
Delay of?
More than 12 years, Lordship.
Charge sheet was filed up to 12 years.
Yes.
It took so much of investigation.
Yes, Lordship.
Means there is 4 units,
Huh?
4 units all over the state, Lordship. And then even initially,
But still-
SIT member was 6 member was constituted. Thereafter, again, there was a reconstruction of this SIT. And during that course, there was some delay, Lordship.
It's too much.
And since everything has to be scrutinized, Lordship, in all those different units, Lordship.
Yes.
It's time consuming.
I will come to later on, Lordship, I may be permitted to come to 120p, but I will deal with that issue when I deal with the discharge petition filed by my co-accused, Lordship. Now, at page 50, Annexure 3 of the criminal revision petition, the date of the FIR.
Next page.
50, Lordship, 50. Annexure 3. This is the charge sheet, Lordship, the first page of the charge sheet. Here, in column 1, the date of FIR is clearly reflected along with the serial number of the FIR. That is FIR number 5/2012, dated 31/07/2012 in column 1. Now in column 3, Lordship, column 2 is the charge sheet number, which is 03/2024. And in column 3, the date is clearly reflected as 26/4/2024, that is 26th of April 2024. Now, my lord, this is also important. The prosecution sanction, Lordship, against me was issued only in the year 2023 in the month of November. After more than 11 years, Lordship, on the verge of my retirement, Lordship.
Okay.
That's it, Lordship, that is the prosecution sanction, the notification, Lordship. I may be permitted to read the last paragraph, Lordship. Now, therefore, the Governor of Nagaland is pleased to accord prosecution sanction under Section 197(1) CRPC against so-and-so, Office Superintendent of PHQ, and Srimati so-and-so, retired Office Superintendent of so-and-so, to prosecute them in connection with the above stated case. Now, Lordship, the date is important.
Can I keep this?
Of course, my lord, my lord.
Date.
23 November 2023.
Yeah.
After more than 11 years, Lordship, after the FIR was filed. Now, my lord, just for my lord's consumption, Lordship, the first page of the papers that I have given, my lord, this is the retirement order of the respondent. He has already retired way back in 2024 in the month of September, Lordship.
He's retired already. He's retired.
Yes, my lord. He's out of service. He has retired, Lordship, and unfortunately, Lordship, he has suffered strokes on a couple of occasions, Lordship. The second one, Lordship, as is the nature with strokes, has been more serious, and he is at present bedridden, Lordship. Which is why, my lord, as I have stated in the first place, I am taking this case as a pro bono matter.
Okay. Good. Next.
First, yes, these are the medical reports, Lordship. In the first page, I will not trouble my lord with the entire records, Lordship. Just the first page, Lordship. It clearly shows that he is suffering from brain problems. Spinal and brain problems, Lordship. Now, at this stage, Lordship, if he is directed to undergo trial, when the essential ingredients of the offense are not there at all, then it will be like sending him to a sentence of death penalty, Lordship. Because, Lordship, I believe he will have a tough time appearing before the court on every day that the case is listed against him. Now, Lordship, the case of the prosecution, if my lord will kindly go to the same page that my learned friend has read, Lordship, page 61, Lordship. Yes, my lord. Paragraph 16.13, Lordship. And 16.15, Lordship, which the learned public prosecutor has already read, Lordship.
14 and 15. 13 and
15. 16.13 and 16.15, my lord.
Okay.
Here, Lordship, the prosecution is relying on the statement of one Miss Scintilla, Lordship, who is
AOS.
PW 19, Lordship. Now,
AOS means administrative officer. Huh?
AO is Assistant Office Superintendent.
Okay.
In the same paragraph in 16.13, it is the acronym is given the longer in longer form, my lord.
Right.
Now, my lord, if I may be permitted to read this 16.3 alone, Lordship, again.
Yes.
Accordingly, Assistant Office Superintendent AOS, Pension Branch so-and-so, was also examined and his statement recorded, whereas his statement corroborated with that of the findings and record of the process of pension cases. He further stated that after the pension is received from TIG headquarters, the pension cases are then scrutinized from their branch, and after obtaining all the necessary forwarding, the pension cases are then forwarded to AG Office Kohima for further course of action. On being asked about the staff who were responsible to look into the pension cases, he stated that Srimati so-and-so was the AOS. Shri so-and-so was the notable officer and was the record keeper who was responsible for all the record keeping in regard to pension cases, Lordship. Now, Lordship, in 16.15, in the course of investigation, it has transpired that so-and-so is also suspected to be involved in the above case. She was examined from pension branch, PHQ, Kohima, etc., Lordship. Now, if, Lordship, the prosecution's case, Lordship, is banking hugely on the statements made by PW 18 and 19 to the investigating officer, Lordship. But Lordship, if this issue has also been addressed, Lordship, by the learned CJM, Kohima, that they only explain, Lordship, that the office procedure, how the files are transferred from one table to another, Lordship. Otherwise, they have nowhere stated that, Lordship, the present respondent or the co-accused person have forged documents, have misappropriated public amount, have acted dishonestly, or have practiced deceit, Lordship. Nowhere it is mentioned. In Lordship, para 25 and 26, Lordship, of the decision under challenge, which is at page 44. The statement of the PW under section 161 has been addressed, Lordship.
Para 25 and 26.
Yes, my lord. '26, Lordship, this is the conclusion. This is the observation of the learned court below, my lord. After the discussion that she has made in para 25. On a perusal of the section 161 CRPC statement of PW 18, she had mentioned the required duty of the applicant in the pension branch, but there was no mention of the forged pension claims documents which were allegedly used by the applicant as genuine. So nothing incriminating has been stated. Now the next PW, Lordship, PW 19.
Okay.
Here also, Lordship, the discussion is at para 27 and the observation is at para 28. On a perusal of the statement of the PW 19, she has merely explained the work of the applicant and there was no mention whatsoever of the use of the forged pension documents by the applicant. Thus, it appears that since the applicant was in charge of the battalion pension cases, the investigating agency has implicated him solely based on suspicion. There is no prima facie material to show that the applicant has used any forged pension claim as genuine. However, merely because he was in charge of the said cases, the investigating agency has brought the charge against him without an iota of evidence to establish the same, Lordship. Now, my lord is well aware that the sea of suspicion has no shores, Lordship. And Lordship, during my service career also, after suffering all the embarrassment, and Lordship, keeping the criminal proceeding against me hanging for more than 12 years, Lordship. Now, even post-retirement, Lordship, they want to crucify me, Lordship, for something that I have never done, Lordship.
Okay.
Now, Lordship, again, finally, Lordship, the last paragraph that I would like to rely on, page 65, Lordship. Page 65, paragraph 16.28 and 16 in
Page
65, my lord.
65.
Yes, this is the charge sheet, lordship.
65. Yes.
Now, lordship, in 16.29, a table is clearly provided. My name and the number of pension cases that each employee have scrutinized, lordship. So, lordship, in column 1 is my name. I have scrutinized. The allegation is that I have scrutinized 10 cases. 10 pension cases, lordship, that is.
Oh.
In serial number 2 is the co-accused, lordship. There is the allegation that she has scrutinized 3 cases, lordship. And in serial 3, there is the allegation that she has scrutinized 5 cases, lordship. Now, lordship, no charges were framed against this serial number 3 when she has, lordship, also scrutinized, lordship. In fact, she has scrutinized more cases than serial number 2. Charges has only been leveled against me and the accused number 2. And lordship, even those employees who ought to have been made accused, lordship, in fact, they were not made accused, lordship. They have been made PWs, particularly PW 18 and 19, lordship. And now they are relying on the statement of who should have been co-accused persons, lordship, and are framing charges against me, lordship. My lord is well aware that the statement of the co-accused is weak evidence, lordship. Now, lordship, at the cost of repetition, as my learned friend has already pointed out in page 67, paragraph 16.36 of the charge sheet, the charges against me under section 468 and 469 have been dropped, which means to show that, lordship, there is no allegation of me ever forging any document.
Well, at the stage of, it has been discharged. No. But it is always plus minus at every stage.
Yes, lordship. Now again,
the evidence, the charge, FIR is filed. No. Then charge sheet plus minus. No. Then charge plus minus, and then final result plus minus. So, but the IO thinks that IO makes a determination that there is no forgery.
Yes, my lord.
Only use of a forged document.
Yes, my lord.
Fine.
Now, my lord, the specimen signatures was taken only in 2022, lordship, in page 75. When the FIR was filed in 2012, after 10 years, lordship. Now a person's handwriting may change. My handwriting may have been very good during my college days. It may not be so good now, lordship.
Yeah, that point cannot be brushed away altogether. Yes, I also feel.
Yes, lordship.
But, basic forensically, to the layman eye, it might look different. Forensically, person may be able to make out. That I don't know. It's a advanced science. But it's the same person. But like our personality, everything, the handwriting may also change a little bit.
Yes, lordship.
It does happen.
Yes.
It can happen.
It can happen.
Yes.
It can happen.
In page 75, lordship.
I've seen people whose handwriting has changed over time a little bit to some extent. I have also seen people whose handwriting has remained same.
Yes,
my friends.
My lord.
Both have seen.
Yes, my lord. Now in page 75 of the charge sheet, lordship.
Next page.
Page 75, lordship.
Yeah, I'm on 75.
Yes, the last column, D18, this is the handwriting specimens, lordship. In the first column, lordship, the dates are provided. All the dates are 2022, lordship.
Yeah, it was taken here.
Yes. So on the 10th year, lordship, and lordship, in the entire case, lordship, no permission from the court under section 311A CRPC was taken for obtaining the signature, the specimen signature of the accused persons. In different high courts, Lordship, there is, Lordship, a slight disagreement, Lordship, that some high courts are saying that, Lordship, permission of the trial court is mandatory
For
obtaining the specimen signatures. Now, some high courts, Lordship,
CRPC allows now.
yes, Lordship, some high courts, Lordship, they are saying that, Lordship, it is not mandatory, but even if it is not mandatory, a speaking order, a recent order must be passed, Lordship.
Specimen in writing. Desirable.
Yes, yes.
Like further
Why specimen signature is required by the original court, by the trial court? That must be passed, Lordship. Here, there is neither.
Anyway, so next. I'll take a short break, 5 minutes.
My lord,
Carry on till she comes.
my lord, my lord. Now,
You also take a break.
my lord, I
Will
will.
you complete? Will you complete?
Yes, my lord, my lord, my lord. 가자. Lordship, this is a decision passed by the Honorable Kerala High Court, Lordship. I tend to agree more, Lordship.
You'll need it back, no?
No, my lord.
I can keep it.
Yes, my lord. I have highlighted the relevant portion, Lordship.
Para 6.
Yes, my lord. If I may, it's a short sentence, Lordship, that it is clear from the wordings of the section itself. The first part of the section says,
Para?
page 5, my lord. Page 5. I have highlighted the relevant portion, Lordship.
Oh.
The second part says that he may make an order to that effect. Therefore, the magistrate, while invoking the powers under section 311A, should pass a speaking order after application of mind to the facts and circumstances of the case, Lordship.
Okay.
Yes, Lordship. Now, this speaking order is non-existent at all in this instant case, Lordship, for obtaining these specimen signatures after 10 years, Lordship, at the cost of repetition, Lordship. There is no permission from the court at all, Lordship. How handwriting evidence is weak evidence, Lordship. It has already been discussed in a plethora of cases, Lordship. I will not, in order to save time, Lordship, I may not read the decision. However, I may be permitted to.
Trial, if one trial comes.
Yes, my lord.
At any trial.
Yes, my lord.
If it commences.
Yes, my lord. But at this stage, Lordship.
It is an opinion evidence.
Yes, my lord. My lord, exactly, Lordship. In 2025, for SSC 487, Lordship, the Honorable Supreme Court has agreed to a decision passed by the Supreme Court itself in 2021, Lordship, that it would be hazardous to base a conviction solely on the opinion of a handwriting
Yes,
expert.
definitely.
Yes, Lordship.
It needs its opinion evidence.
Yes, my lord.
It does need corroboration.
Yes, my lord.
Though forensic opinions may be different because times have also changed.
Lordship.
You know,
Lordship.
the times have also changed because sometimes I feel the feature of evidence will be scientific and documentary.
Yes, my lord.
Scientific evidence.
Yes, my lord.
Because oral evidence through the prism of a human eye is always risky.
Yes, my lord. My lord.
You may perceive it like
Yes,
that. I
my
may
lord.
perceive it
My
in
lord.
different
My
way.
lord.
But opinion evidence, yes. Forensic is also an opinion evidence, but the science is very accurate.
Yes, my
But
lord.
the opinion given, so somewhere
Yes.
new laws will emerge perhaps.
My lord. My.
So anyway, so 25 4 SCC 487.
Yes,
This
my
is
lord.
Kamala Kannan.
Yes, my lord.
See. Kamala Kannan.
Yes, my lord. Now, Lordship, during the entire investigation, I was summoned.
The para, which para?
Para 12, Lordship. I don't have the Lordship, the SCC copy with me, Lordship, but from the original, in the original decision, Lordship, it is para 12.
Check.
My lord can keep
No,
this
it's not
copy.
para 12 here. Something, it will be different.
In para 12 here, Lordship, Murari Lal versus State of MP is quoted. The locus classicus of this issue is, it starts from those words, Lord.
Para 13 here.
My lord, my lord.
They changed it.
My lord.
Anyways.
Now, Lordship, in the entire investigation, during the entire investigation of more than 12 years, the respondent was summoned only once, Lordship, in either in 2024 or 23, Lordship. That is after more than 10 years has lapsed. And then, Lordship, when nothing incriminating was found against me, the alia concocted his own story, and then I was coerced, I was pressured, I was summoned to Jumu, which is another district from the next district from Kohima, Lordship. When the case is a Kohima case. But be that as it may, my lord is well aware that the statements made before the police, Lordship, is not admissible in evidence, Lordship. Lordship, now, no loss has been caused, Lordship, to the state. The Honorable Supreme Court, while dealing with the case, Lordship, under Section 468 and 467, Lordship, a 5 judges bench of the Honorable Supreme Court, Lordship, in 1963, AIR SC 1572, Lordship, Dr. Vimla versus Delhi Administration. Paragraph 14 is relevant, my lord.
This name of the decision, Dr. Vimla.
Yes, my lord. It's a judgment delivered by Justice Subbarao, Lordship. I have always been fond of reading his judgments on criminal law, Lordship.
Which para? This one?
15, my lord. Now let us apply the said principles to the facts of the present case. Certainly, Dr. Vimla was guilty of deceit, for though her name was Vimla, she signed in all the relevant papers as Nalini and made the insurance company believe that her name was Nalini. But the said deceit did not either secure to her advantage or cause any non-economic loss or injury to the insurance company. The charge does not disclose any such advantage or injury, nor is there any evidence to prove the same. The fact that Dr. Vimla said that the owner of the car who sold it to her suggested that the taking of the sale of the car in the name of Nalini would be useful for income tax purpose is not of any relevance in the present case for one reason. The said owner did not say so in his evidence, and for the other, it was not indicated in the charge or in the evidence. In the charge frame, she was alleged to have defrauded the insurance company, and the only evidence given was that if it was disclosed that Nalini was a minor, the insurance company might not have paid the money. But as we have pointed out earlier, the entire transaction was that of Dr. Vimla, and it was only put through in the name of her minor daughter or for reasons best known to herself. On the evidence as disclosed, neither was she benefited nor insurance company incurred loss in any sense of the term. Of course, Lordship, this is a case of 467 and 468, Lordship. But on that ground, Lordship, that no loss was or injury was caused to the other party, the complainant party, the complainant company, Lordship, she was acquitted, Lordship. Now, Lordship, the delay, Lordship, in filing the FIR, Lordship.
Delay in registering the FIR.
No, Lordship, delay in completing the
Investigation.
investigation and filing of charge sheet, Lordship, delay in the issuance of the prosecution sanction, Lordship. If I may be permitted to take my lord to Lordship, 2008 16 SCC 117. 2008 16 SCC 117.
2008.
Yes, my lord.
Can you repeat? 2008.
16 SCC 117.
117.
The name of the case is Pankaj Kumar was the state of Maharashtra. Yes, 16 SCC 816. Lordship, I would like to rely on para 25, Lordship. Here the investigation took 8 years, Lordship. The relevant paragraph is at page 127. Though if it is true that the plea with regard to inordinate delay in investigations and trial has been raised before us for the first time, but we feel that at this distant point of time, it would be unfair to the appellant to remit the matter back to the High Court for examining the said plea of the appellant. Apart from the fact that it would further protract the already delayed trial, no fruitful purpose would be served, as learned counsel for the state very fairly stated before us that he had no explanation to offer for the delay in investigation and the reason why the trial did not commence for 8 long years. Nothing whatsoever could be pointed out, far from being established, to show the delay was in any way attributable to the appellant, Lordship. Now in the next page, Lordship, paras 28, 29, and 30. Thus, on facts in hand, we are convinced that the appellant has been denied his valuable constitutional right to a speedy investigation and trial, and therefore criminal proceedings initiated against him in the year 1987 and pending in the court of the special judge Latur deserve to be quashed on this short ground alone. For the view we have taken, we deem it unnecessary to go into the merits of the accusations against the appellant, as also the question of his age at the time of commission of the alleged offences. Lordship, so solely on the issue of delay, Lordship, in completing the investigation, in 8 years, Lordship, the FIR was quashed. Lordship, similarly, Lordship, in 2022 SSC Online TEL 3365, Lordship. No. Paragraph 12, Lordship. Here, there has been delay of more than 10 years.
Para 12.
Yes, my lord, para 12. It's a short paragraph, Lordship. There has been an inordinate delay for more than 10 years in filing the charge sheet, which is yet not filed for want of sanction. The delay in investigation is not attributable to the petitioner. In my view, the respondent has not been able to justify the inordinate delay in filing the charge sheet and concluding the investigation, Lordship. After this, Lordship, paras, Lordship, 19. Para 21, Lordship. Since I am quashing the FIRs on the aforesaid grounds, I do not deem it fit to give reasons on merits or demerits of allegations in the FIR. Lordship. Now, this also solely on the issue of delay, Lordship. The FIR was quashed. Here, Lordship, the investigation took more than 12 years, Lordship. Whereas in the cases that I've read out, the first case, Lordship, it took 8 years. In the second case, it took 10 years, Lordship, for filing of charge sheet. Now, lastly, Lordship, on the ground of parity, Lordship, This is my last. Wrong logic.
This we have seen.
2023 9 SCC 164.
I'll write it down.
Yes, my lord.
2000
2023 9 SCC 164. Paragraph 15 is relevant, lordship.
964.
164.
Sorry.
Yes, my lord. 164.
Wait, just a. We'll write down.
Paragraph 15 is relevant, lordship. It's a short paragraph, lordship. In paragraph 15, lordship. When there is similar or identical evidence of eyewitnesses against two accused by ascribing them the same or similar role, the court cannot convict one accused and acquit him.
Sorry,
15, my lord.
Para?
1-5
Just.
at page 175, lordship.
Yeah, what is similar identical? Yeah.
When there is similar or identical evidence of eyewitnesses against two accused by ascribing them the same or similar role, the court cannot convict one accused and acquit the
Here,
other.
principle of parity will apply.
Yes, my lord. Here, lordship, why I am raising this, lordship, it is because the last annexure to the criminal revision petition, this is the order by which the discharge petition of my co-accused was allowed, and state has not preferred any.
That may not be a ground for, for them to say, but yes, it's for them to, because, and another reason is that you have also given conspiracy as one of the sections.
Yes, lordship.
Suppose it proceeds, then automatically conspiracy will fail.
Yes,
There
my
cannot
lord.
be one person.
Yes, my lord.
Anyway, that's for the state to take a call.
Yes.
But yeah, not that it does not come to your aid directly, but yes, you can always point out that aspect.
Yes, lordship, lordship.
That is all.
As my lord has rightly pointed out, lordship, 120p, lordship.
Yeah.
Can no, yes, can no longer.
Criminal agreement.
Yes, my
In
lord.
any agreement, two persons.
Yes,
at
my
least,
lord.
at least two persons.
Yes, my lord, my lord. That,
We all know.
yes, my
No,
lord.
The juniors should know better because they are more fresh and up to date with these basic things.
Lordship, now, in the law of discharge, the law is well settled that when two views are possible, one, lordship,
Discharge, there, of course, the settled principles are like this, that you cannot do mini trial, you cannot do appreciation of evidence. Right. If there are prima facie clearly materials, then obviously you cannot discharge. But the gray area and that slightly difficult area is the principle which the trial court has used, I have seen. P. Vijayant's case, grave suspicion and suspicion.
yes, my lord.
That degree, what is grave suspicion, what is suspicion? Sometimes one can make errors in that.
Yes, my lord.
But there's no formula.
Yes, my lord.
That is a degree.
Yes, my lord, my
There's
lord.
a formula.
Yes, my lord. In fact, lordship, not only in B. Vijayan, that same law has been laid down, lordship, in
Yes.
lordship, in 2010, 2 SCC 407, lordship.
407.
Yes, my lord. In that same volume, which consists of P. Vijayan, lordship. P. Vijayan is 298, 398, lordship.
Famous case. This principle was enunciated for the first time, I think. That means it said, if I remember correctly, is that when grave suspicion and suspicion, there's suspicion but not grave suspicion, then the court may be justified.
Yes, my lord.
The court may frame charge also, but the court has a discretion. In my opinion, that is one of the most, challenging areas of discharge jurisprudence.
Yes, my lord.
Discharge jurisprudence.
My lord, my lord.
Because we can never give a formula. It will depend on facts. If you think, you have to also apply common sense. If the court thinks that yes, there are materials, at least the prosecution should be given a chance to adduce evidence, then it will be justified to frame charge. Otherwise not.
There are other decisions also, Lordship, passed by the Honorable Supreme Court on that same principle, Lordship. If my Lord,
For a criminal court, the default setup is framing, because it's easy to frame a charge.
My Lord.
Much more difficult to discharge because
My
you
Lord.
have to justify.
My
So natural tendency is to, if there are some materials, you
My
have
Lord.
seen
My Lord.
there's a tendency to,
Yes.
where there is genuine grounds for discharge and the court takes trouble to, go into that, that's okay, that's appreciable.
My Lord. My Lord.
But of course, higher court in a revisional jurisdiction has to see whether that jurisdiction has been exercised correctly or not.
Yes, my Lord. Now,
Otherwise, most courts have a tendency not to take the trouble
My Lord.
unless the defense counsel has, taken the pains himself on his part
Lord.
to place materials and specifically apply for discharge. Because
My
many a time the defense counsel will also say that
yes,
the charge,
my
let's go ahead.
My Lord.
Let's go ahead.
My Lord.
That's
My
my
Lord.
experience.
Yes, my Lord.
It's okay. I mean, if they are suppose 302 and everything is there, then what
My Lord.
charge will you
My
try?
Lord. My Lord. My Lord. I believe, Lordship, allowing discharge petitions, Lordship, it also saves public time and the court's precious time, Lordship.
Forget in a particular case, if there are merit in discharge, then the person should not be made to go through trial.
My Lord. My Lord.
Then only the public thing comes.
My Lord.
The person should be safe. But the thing is that again, why there are also reasons why the courts have a greater tendency to frame charge if there are prima facie some materials, because walking on this path of whether there is materials to discharge is not a very easy path.
Lordship. Lordship. Lordship.
That's why I say that the court will be a criminal court will be more willing to walk on that path if it is made to do so by the defense counsel.
Yes, my Lord.
By
My Lord.
filing a discharge
Yes, my
application,
Lord. Yes, we did
taking
that.
a hearing,
Lordship.
giving material.
Yes, my Lord. We did that, Lordship.
Anyway, so this is para 10.
Yes, my Lord. So, my Lord.
No, this is Vijayan only.
Yes, B. Vijayan only.
Oh,
Lordship. Yes.
So 2010 to SSC 4.
Yes, 39.
407 is different one.
Yes, my Lord.
Okay,
Lordship, I may be permitted to, if
the different one.
Yes.
Vijayan is, I'll write down also. Vijayan.
if my Lord.
I need not write down. Given so.
Let's see.
Okay.
If my Lord would permit me to submit other citations on that principle, Lordship, on B. Vijayan's principle, Lordship. In order to save this court's time, Lordship, this honorable court's time.
Oh, so you'll submit later.
Yes,
You
my
can.
my Lord. My-
Because I also want to see, because it's 2010, I want to also see that in recent years, how this principle has
Evolved.
been applied.
Yes, my Lord. Lordship, now, basically, in a crux, Lordship, the essential ingredients 120p no longer exists, Lordship, since there is no co-accused in this case.
No,
Lordship.
see it like that. 120B, because well, yes.
Yes.
Yes,
Lordship,
because so far they have not filed.
yes.
So we have to forget about that.
Yes, my Lord.
Yes.
My Lord. My Lord. It
That's
may be revived, Lordship, if
120, that way, no. It's
yes,
not.
my Lord. My Lord. Tapandas, Lordship, 1955 AIIC. It's very clear, Lordship.
No,
Yes.
obviously, it's,
For 120p, a sole accused cannot be prosecuted. Now, so far as 409, Lordship, 420 is concerned, Lordship, there is no entrustment, there is no deceit, there is no delivery of property, there is no conversion, Lordship. And Lordship, even in fact, Lordship, the requirements of property alone, Lordship, it has not been satisfied, Lordship. And Lordship, so far as 471 is concerned, Lordship, 471, Lordship, 468, Lordship, is an essential ingredient.
yes, that
Yes, Lordship.
it's a very nice judgment on that point.
Yes, Lordship. Now, when there is no 468, Lordship, 471 cannot be attributed to me just like that, Lordship, just blindly, Lordship.
No, 468 is forgery
Yes, my lord.
and 471 is for use for.
Yes, Lordship.
No, I think it can be because suppose I have not forged the document, but I have a document which I know to be forged.
Yes, Lordship.
And I'm using it.
Yes.
Then it can come. I have
Now-
to know what.
Yes, Lordship. But in the entire prosecution's case, Lordship.
I'll see that.
Yes, Lordship. In the statements of the PWs, Lordship, there is no allegation. None of the PWs have stated that I had knowledge that the documents in question were
That's
forged, Lordship.
circumstances anyway, but I have to see the material.
And Lordship, on the issue of delay alone, Lordship, without entering into the merits, Lordship.
Okay. You've submitted, if you get some more recent decision regarding delay investigation, whether delay will justify quashing. This is not a quashing petition, but
Yes.
revision, similar restriction.
Yes, my lord. But here, Lordship,
So that I will also look. But
yes,
I
my lord.
get time.
Again, Lordship,
You can help me, say you can send letter also.
yes, at the cost of repetition, Lordship, in revision petitions, Lordship, perhaps, Lordship, the powers of this court is a little constrained. Lordship.
Constraints.
Yes, Lordship.
Yes, it's quashing is somewhat
I guess
quite.
the discharge petition.
Yes.
Lordship,
And that petition has already been allowed, Lordship.
Anyway, so
So unless it is perverse, Lordship, or patently illegal, just because a different view is possible, Lordship, it may kindly not be deferred, Lordship. Otherwise, my lord, as Justice Benjamin Nathan Cardozo said, judge-made law is one of the existing realities of society. On the same evidence, two judges may draw very different perceptions and conclusions, Lordship.
anyway, so okay.
My lord.
That much.
My lord.
Anything you would like to briefly reply?
No.
No. So I'll close it. Huh?
My lord, I'm deeply obliged for giving me a patient hearing, Lordship.
Thank you very much.
Since Lordship, it's already past 4, if I may be permitted to furnish those judgments to your secretary tomorrow morning, Lordship.
No problem. You can give it tomorrow morning.
My lord.
Or day after tomorrow.
The books which you will use, you want to copy.
No, I'll see. If I need it, I'll take. Probably I'll need, but I can take out the relevant pad also. Not the whole. Okay. Anyway, call her, write it in the chamber.
Deeply obliged, my lord.
No. Is the name of Mr. Jiman Sentiangi. Serves names also, assisted by, give the names of junior counsel. Heard. Arguments concluded. Original record is here. Arguments concluded, judgment reserved.
Deeply obliged, my lord.
Bless. Okay.
No.
My name is Alam.
Exercise illusion ni kumai kami. Okay.